such a long time for 3-4 days.
My signature was not there in the serial list.
Has submitted that another has been falsely implicated in this case. He was not present at the spot where the contraband article was allegedly recovered from one Hiralal shop. However, the motorcycle belongs to the present petitioner, as the charge sheet has already been submitted, and as there is no incriminating material against the present petitioner, he may be enlarged on bail considering his period of detention. Stop. The learned counsel for the state has raised strong objection. According to him, there are sufficient incriminating materials showing that the contraband article was being carried in the motorcycle of the present petitioner by one Hiralal. Stop. In view of the above, his prayer for bail, in view of the above materials, his prayer for bail should be cancelled. Should be rejected. So, we have considered the materials on record. Petitioner is in custody for about 166 days. However, there are sufficient incriminating materials showing that contraband article was being
showing his involvement in the alleged
crime. Therefore, bail stands rejected.
Grateful. He was not riding the bike. Bike was in a standing position, my lord, in a mango orchard. When Hiralal was also in standing position.
standing, sitting, lying, whatever it is.
Every factual aspect will be considered at the time of trial.
Then, my lord, it is suspicion, my lord, my liberty.
At this stage, suspicion.
Mr.
Police has the right to raise suspicion, legal right to raise suspicion for our citizen.
My lord.
That we do not have.
But when we are appearing on behalf of
legal right to raise suspicion.
Mr. Akram, recently in another case, copy of a judgment was handed over to us. Justice Bela Trivedi's judgment, very recent, where she says that jail is the rule in NDPS case, bail is the exception, and very, very sparingly in exceptional cases, because it is such a social menace. It destroys families.
Yes,
it destroys the economy. So, only Article 21 will override everything.
Subject to correction from my lords, my lord. And at the same time, that my lord, what is the nature of evidence against the accused person that needs to be looked into.
It's too early. Too early.
Yes, my lord. Grateful.
Well, I'm for the petition. Well, more than 2 years, 3 months, report was called for. I also take instruction at least on 5 dates, my lord, no witness has come to depose. My lord, 2 schedule has been failed. And my
here the my lord, chemical examination report, my lord, came on my lord 12 March 2024. Thereafter, supplementary charge sheet was filed. My lord, the charge was framed on 9th May 2024. My lord, since the first 3-4 dates, my lord, the PO was on leave. So, my lord, the matter could not be, the evidence could not be, my lord, taken place. My lord, thereafter, my lord, from 7/11/2024, my lord, 2 witnesses did not turn up. The next date is on, my lord, 27 January 2025, 28.
So, not a single witness has
no, not.
How many witnesses are there?
My lord, total 14.
14.
My
Issue.
lord, 5 liters of protein mixture was recovered from.
So,
with very heavy heart, we have to grant what
No,
to do.
since the chemical examination report, my lord, was awaiting, my lord. As such, my lord, the delay was there. It came in 2024.
Report filed by the state be kept with the records. Stop. Paragraph. We see that charge sheet was filed.
Yes.
4th April 2022.
23.
When?
22.
23, my lord, the charge sheet was filed.
When date?
My lord, 27th March 2023.
Charge sheet was filed on March 7, 2023. Stop. However, charge was framed
Charge was framed, my lord,
9th May.
9th May 2020.
on May 9, 2024, i.e. after 1 year, 2 months. Stop. Thereafter, there has been no progress in the trial at all. Stop. There are 14 charge sheet named witnesses. Stop. Not a single witness has been examined. Stop. It is not the case of the state that the petitioner is to be blamed, to any extent, for the delay in progress of trial. Stop. Paragraph. In the aforesaid facts and circumstances of the case, we see that there is no possibility of an early conclusion of the trial. Stop. The petitioner is in custody for about 2 years and 3 months. Stop. Without touching the merits of the case and solely on the touchstone of Article 21 of the Constitution of India, we feel constrained to enlarge the petitioner on bail.
Conditions, sir.
All tell us what condition?
That usual conditions.
Usual condition.
Well, only mean that the charge sheet was submitted
where
in the year 2022.
Two. Which
Instead of
date? Which
23,
date? Which
date
date?
is 7th March 2022.
March 7, 2022. তাহলে ওটা হবে
তাই তো?
after 2 years, 2 months.
I'm replying.
The report be kept with the report.
হ্যাঁ, ওটাকে রিপোর্টটাকে রেকর্ডে নিন।
I'm for the petitioner.
I'm for this.
Yes.
And I prefer bail on the two grounds. One is, my lord, 1 year I am in custody. Witness actions not started. 12 witness to be examined. My lord, this is one. And two is, my lord, his wife is suffering from cancer and at this advanced stage of cancer. My lord, if, my lord, in any stringent condition, my lord, I can be allowed with my wife to stay for the last times. Even in interim bail, my lord, I have annexed all the medical documents, page 7 onwards.
Around 352 kg of ganja was recovered from the secret compartment from the driver's chamber of a truck. And my lord, already PW1 chief has been partly done out of 12 witnesses. And my lord, charge framed on September 24. And my lord, already
My lord, it is written here.
Oh, Shiuli Mondal.
Shiuli Mondal.
What is your name?
Anishur Mondal.
Mongol or where?
No, Anishur Rahman Midda. Anishur Rahman Midda. এটা কি? দাঁড়া বাবা হতেই পারে বিয়ে করেছে আমি কি করে জানবো দাঁড়া দেখছি
So compatible with the first title of your and
My lord, it is handed over my client that claiming. My lord, lordship can infer that whether she is my wife or not. If he is playing, even if he is my client playing with the court, my lord,
carcinoma. Carcinoma, where is the population that he's suffering from carcinoma? Hypertension or
my lord, let that medical document be inquired and
officer of the court. Your duty it is.
my lord, here it is written.
Please.
দাঁড়া
Why
আমি
you
মেডিকেল রিপোর্টের ভিতরে যাই
document without perusing the same?
দাঁড়া না ফাইলটি কোথায় পাবো রে এগুলো পড়াও মুশকিল ডক্টরস নোট
Your juniors certainly have done Here may not be enough time, sufficient time. That's why junior advocates are employed.
অ্যাডভান্স না ক্লিনিক্যাল নোটস গুলো দেখতে হবে মানে give me one day time মানে
One day time.
Not today.
let me
Learned advocate for the petitioner seeks a day's accommodation to obtain better instructions.
Aadhaar card is available. On which?
Let the matter be listed again on Friday. Friday. Friday.
নি নালে গন্ডগোল হবে। ওগুলাই।
Item 28.
Your Lordship kindly sees the Lordship's last order. The petitioner says that he's in custody for more than 8 months. The alleged seizure from the house was not videographed. There is no independent witnesses to the seizure. He relies on an order dated such and such, passed with coordinate bench in such and such, prays for bail.
Your Lordship, I have given the report.
Only one copy.
Copy. Three copy, Your Lordship, kindly.
There you are.
All stapled together.
Yes, yes.
Yeah, there are total 14 charge sheeted witnesses. How long you are in custody?
9 months.
Charge
Next
was-
date has been fixed for charge period.
Yes,
Charge has not been framed.
not yet.
What is the date fixed?
25/4/25.
25/4.
Yes, Your Lordship.
Open details in charge?
এত long date কেন?
Contraband articles.
400 bottle of PROCEEDINGS recovered from his bedroom. There is no, Your Lordship, that instruction I don't have.
So, why you are objecting to his bail bail? What are the grounds for your objection?
From his house that has been recovered. Yes, Your Lordship. He was staying at that time he was staying in that room.
Come back after some time.
My lord, Your Lordship, then Your Lordship, see the order of the coordinate bench in this case.
What
There is no videography is there. There is no independent witness at the time of seizure.
Videography.
No videography is there.
That time
If
there was no
investigation agency fails to
Argue that point at the trial.
Your Lordship, on this court, Honorable Court granted
Issue.
bail also. Your Lordship kindly see.
We are not inclined, sir. We are not inclined.
Then I'm withdrawing my application.
Not inclined.
No independent witness was there.
Not always necessary. You want the Supreme Court decisions? Not always necessary for conviction.
My lord, I am for the petitioner.
And for the state, Your Lordship.
My lord, the FIR is dated 1st of May 2024. I was arrested on 1st of May 2024, allegedly with possession of 27.865 kgs of gaja. My lord, on 18th of October 2024, without even filing the formal charge sheet before the learned vacation court, the IO prayed for extension of time. My lord, even on that date, no formal charge sheet was filed. till, my lord, on 4th of November 2024, the petitioner prayed for statutory bail in person. That was a 188th day. Till 4/11/2024, that is the day when I prayed for statutory bail, there was no charge sheet on record, no chemical report on record. My lord, my prayer for statutory bail was rejected. Charge sheet with chemical report was submitted. The charge sheet dated 5th November 2024 with chemical report was submitted before the court on 6th November 2024. So, my lord, I am entitled to statutory bail because till 188th day there was no charge sheet with chemical report. My lord, I have annexed the charge sheet. If your lordship kindly sees, my lord, if your lordship kindly comes to the charge sheet, my lord, that is the 4th last page of the petition. My lord, charge sheet dated 5th November 2024, seen on 6th November 2024. And that was the 189th day. My prayer for statutory bail was rejected on 4th November 2024.
On which ground? What is the ground for rejection?
Because my lord, the order is, I have annexed, the rejection ground was that since the IO has prayed for extension of time on 18th of October 2024, I am not inclined to grant the statutory bail.
So I have the legal right to.
My lord, my lord, I am covered by Idul Mia. Because my lord, till my lord, bail application, chemical report was not there on record. Charge sheet with chemical report was not there on record.
The FSL report has not been submitted.
Yes.
No. It was submitted on 5th of November 2024.
From time. We have prayed for
Yeah,
time.
Valki.
That was allowed.
File a report.
My lord, I have annexed the charge sheet report. My lord, FSL report was submitted on 5th of November 2024, 6th of November 2024.
The petitioner says that he is entitled to statutory bail.
Allowed.
Stop. Statutory bail was wrongly denied to him by the learned trial court. Stop. Paragraph, let the state file a report on the next date. Paragraph, list the matter. You're going out when?
9th.
9th?
9th night.
That 20 তারিখ Kumbh.
Oh.
Going to earn Punno.
This is a Purno Kumbh also. Once in 180 years.
Once in?
180 years.
144 years.
144 years. This is a
Purno?
no, my lord, Purno Kumbh.
Only Kumbh.
Yes.
And this is Purno
Purno Kumbh after 144 years. 144 or 188 years. 144. 144.
Very well. We'll go to the next one.
Grateful to your lordships.
Please specify.
I'm for the petition.
Before he starts, we've got the report. Today is the date fixed for the judgment in the trial court.
Judgment.
Yes, my lord. So, my lord, probably
Come to this.
I don't have instruction to that effect.
we've got the report.
Yes.
This is
But I was told that out of 13, 7 witness was it.
no, total 9 witnesses have been examined, but that's all what the prosecution intended.
Report filed by the state be kept with the records. Paragraph. We find that today is fixed for delivery of judgment by the learned trial court. Paragraph. In view of the aforesaid, there is no question of entertaining this application for bail. Paragraph. Dismissed.
Great.
Grateful.
Good luck for your judgment.
You may be acquitted. Grateful, man.
Grateful.
Oh, good luck, Sassi. চৌধুরী সাহেবকে যেন খবর দেওয়া হয়।
My lord, I am for the petition, my lord. This is my renewal bail applications. The last was rejected on 1st March 2024. We directed to my lord. We haven't considered the materials on record. It is 22.74 gaja was recovered from the dicky and vehicle.
23?
22.743 kgs gaja, 22 kilo gaja, just more than.
Sole accused.
No, he is in second accused, my lord. The others prime accused is already on bail and third accused already on bail, my lord. In second renewal bail applications, my lord.
Joint position, no. See the list.
First accused and third accused already on bail, my lord. Please. Isn't third. My lord, he has submitted that at the time of the bail application of Rajesh Bhagwa, he has stated the prosecution's counsel has stated 22 kilo charges. Now he is stating the 8 kilo, my lord. At the time of submissions of this 24th April 2023, he's obtained the third accused bail already in this matter, my lord.
No, this is on humanitarian grounds. We had granted interim bail.
No, my lord, I have already submitted the order sheet of this 24th April 2023. Rajesh Das Bhagwa.
Yes.
NDPS number 540.
Oh, Rajesh Das.
Page number 80, my lord, of my applications.
Yes, what, Mr. Banerjee?
Already 10 in this matter, my lord. Last directions was in this matter.
How long are you in custody?
2 years, 1 month, my lord. 2 years.
I am placing the list of dates, madam. Kindly tell me, sir, who are taking.
Only one witness is covered, my lord,
How many
out of
witnesses
10.
have you examined so far?
only one. Examine and cross-examine.
My lord, only one has been completed.
File a report.
My lord, I have filed.
My lord,
I have-
2 already.
Does it say how many more witnesses you wish to examine?
Only one. After 10, before
10.
total 10.
My lord, kindly verify the-
Before 10 months, madam, my last bill application, my lord, was there also the one witness. Today, after 10 months,
July,
my lord,
July.
my lord, after 10 months, the same position, my lord, today.
Witness present.
Only one. Only one witness. Examine and cross-examine. Not completed 2 witness, my lord. Before 10 months, before the same standing today also, my lord. Nothing has been taken. And already 2 accused already on bail.
How does he stand on a different footing from the other 2 accused?
Same footing. Same FIR, my lord, and the same FIR.
Instruction from Rajesh, position 8 kg of Naja, which is.
File a report. The petitioner is aggrieved since he is in custody for about 2 years, 3 months. Stop.
1
Only
month, my
2
lord. 2 years.
2 years, 1 month. Stop. Only 1 out of
10 witness. Already examined and cross-examined.
That's what is it? Only 1 out of how many charge sheet named? 14.
It has been filed, my lord, 2023, my lord.
Oh, how many charge sheet named witnesses
10.
That's not the query. Only one out of blank charge sheet named witnesses has been examined. Stop. He renews his prayer for bail on the ground of delaying progress of trial. Stop. He further says that the other two accused persons
Already arrived.
are out on bail. Stop. He stands on a similar footing. No, similar footing.
Same.
And therefore, charge sheeted witnesses. So you will examine all 10.
All 10.
Only 1 out of 10 করবে ওখানে যেটা blank ছিল না
My last
stands
application
on,
was at the time
on
of
the same footing,
Today also.
Stop. Paragraph. Let the state file a status report. Stop. The report shall indicate inter alia, how this petitioner is differently circumstanced from the other two accused persons who have been granted bail. Stop. We have noted from the report filed today, are we filing something today? That the state proposes to examine all 10 charge sheet named witnesses, out of whom only one
examined
has been examined in full.
and cross-examined. Only come.
Stop. Paragraph. We further see that January 15, 2025, is the next date fixed before the learned trial court. Stop. List this matter. এই 15 পর NDPS কবে আছে?
Next date is 15.
15 তারিখে একটা NDPS date. Oh. 20th.
Last two occasion defense took time. Last 4 occasion.
And 32. Wait, please, Your Lordships. My lord, I am in custody for about 1 year, 2 months, 15 odd days. My lord's pleasure would be kindly to come to page 29 for a moment. My lord, on the 176th day, which is within the statutory period, my lord, the public prosecutor forwards a report in terms of section 36A(4). My lords would kindly have the report for a moment. My lord, there are twin conditions which are required to be satisfied in terms of the Sanjay Kedia's judgment. I'm carrying the judgment, which has been subsequently followed by Your Lordships as well in other judgments. But twin conditions are: one is the progress of investigation. Second is mandatorily as to why the detention of the accused has to be prolonged. My lord, the second limb is absolutely conspicuous in the entire report, my lord would find. But this was illegal at the first place. Now, my lord would kindly come to the order sheets for a moment. That is at the end, my lord. My lord, kindly see the report, my lord, of the public prosecutor at page 29. It's not there, not even a line or a word has been spent on that.
Page
29.
Page 29, my lord. না 29 তোমার এই পিপি রিয়েটা গো কোনো কিছু লেখা নেই।
গন্ডগোল আছে অর্ডারটা কি বলছে?
Condition, I think. Yes, once again.
The act reads mere specific reasons for the detention of the accused beyond set period of 180 days. 36 A(4), my lords.
My lord, I have filed bail applications subsequently. That was challenged. My lord, 16-4 is the order. My lord, would kindly have the judgments of the Honorable Supreme Court on this point. My lord, I'm carrying Sanjay Kedia. My lord, the first three judgments on this point. My lord, 1 and 3 would squarely cover me at least. My lord, one is Sanjay Kedia's judgment by the Honorable Supreme Court. My lord, it is a
Consider and come back.
I mean, may just take a little further. My lord, even otherwise, my lord, I'm covered by Idul Mija.
No, either you are relying on
My
this
lord,
or
there
you
are
are
two
not.
very good my lord, things.
Are you relying on this? Then we'll have to grant him time to consider this.
Well, I can show Idul Mia's violation as well in this case. But case of too many
You
good
have not
points.
answered up my
I
query.
can understand, my lord. Well, I'll not rely on them then, my lord. I'll just
Take away. Yes.
well, may I just show your lordship the next limb of my argument. Now, my lord, after
So
this, my lord,
36A4, you are not arguing.
my lord, 36A4, I'm arguing, my lord, I'm not, well, it is my lord, from the bare act only, my lord, it is apparent.
Okay.
It is not this. The second condition is not there, my lord.
That
lord,
we will see. We will see.
The
You
second
know us, you know.
My lord, may I show you, lordship, one more thing, my lord. My lord, 16-4, it was, my lord, kindly take up the, my lord, order dated 16-4-2024 for a moment.
Sixteen four
2021 for a moment.
24.
2024, my lord. 16-4-2024, my lord. Order sheet.
Yes.
My lord, we challenged this extension after hearing both the sides. The learned special court was of the opinion that 1 month time is hereby extended on and from today, that is 16-4-2024, to complete the investigation and to submit a report in the meantime. Now, my lord, now that expired on 15-5. My lord would kindly flip over one page, and the very next page, my lord would find the 15-5-2024 order, which is the 30th day of extension. In my opinion, illegal. Now, my lord, this charge sheet comes to be filed without the chemical report. That is not there.
When?
My lord,
15-5.
on 15-5, the primary charge sheet is filed.
Arrested?
Arrested on, my lord, 2010-2023. 2010-2023, my lord. Charge sheet filed on, my lord, 15-5-2024, which is the 210th day in terms of the extension.
Within extended time period?
Within the last day of extended time period.
Without FSL?
Without FSL. The very next day, my lords would find at 16-5-2024, I take out my application for statutory bail, citing that the CFSL report is not there. While recording my submissions, the learned trial judge, the learned special court records that the right of accused to be enlarged on default bail ceases to exist as soon as charge sheet is submitted. Admittedly, till that point, charge sheet was, my lord, the CFSL report was not there.
Idul Mia was not there.
But here also it is not there. The CFSL report was not there.
Idul Mia was not there before the learned trial court.
But Rakesh, no, Rakesh.
Rely on 36, before, give him time, come back. Good suggestion, give him. Otherwise, you shall reject.
Well, CFSL report was not there, my lord. Admittedly, my lord. Rakesh,
Covered by Idul Mia. No.
After
On
16.5 itself.
After the bail prayer was rejected.
Was granted by the Constitution. The FSL report along with the supplementary charge sheet was notified. He prays for default bail on 16.5. On 16.5 itself, the FSL report is filed before the court.
Yes, but after he applies for statutory
After
bail.
my bail prayer is rejected even.
Once he applies, he's right.
He is right according to
M. Ravindran.
Subsequent filing will not affect that right.
that perhaps might be true, but only since we are still at a stage where Idul Mia has not yet
Been tested.
court is still not decided the fact that whether this will
That is why
cover 160.
that is why interim bail. Because in all cases, if Idul Mia we are granting interim bail, then why not here?
This is simply that in his best cases that he had applied for default bail, it was not there, but the same day the CFSL had come.
After rejection of
rejection.
After, that is there in the order. Go back.
The petitioner says that he was arrested on October 2020, 2023. Stop. The charge sheet was filed on May 15, 2024, i.e. within the extended time period, on the 210th day after his arrest. Stop. However, the charge sheet was not accompanied by the FSL report. Stop. Hence, on the very next day, on May 16, 2024, he applied for statutory bail. Stop. Such application was dismissed by the learned trial court. Stop. Hence the present application. Paragraph. Learned state advocate points out that the chemical report was filed on May 16, 2024, i.e., the day when the petitioner applied for statutory bail. Stop. Paragraph. However, we see that the FSL report was filed after the statutory bail prayer of the petitioner was rejected by the learned trial court. Stop. Therefore, the filing of such subsequent charge sheet would not affect the petitioner's right to obtain statutory bail which accrued in his favor prior to filing of the FSL report. কি বললাম এটার আগে এই সেন্টেন্সটা? Therefore subsequent charge sheet na subsequent FSL report obtained. This bench has held in the case of Idul Mia reference that in an NDPS case, a charge sheet filed without the FSL report is not a charge sheet within the meaning of the provisions of CRPC. Stop. Paragraph. Hence, we are inclined to grant interim bail to the petitioner. Stop. We do this keeping in mind that in similar cases which have been carried to the Honorable Supreme Court, the Honorable Court has granted interim bail pending a decision on the issue as to whether or not a charge sheet in an NDPS case must mandatorily be accompanied by the chemical report. Stop. Accordingly, interim bail kore dao, kore ja usual condition, next para, this order of interim bail shall continue till the end of February 2025, or until further order, whichever is earlier. Stop. Next para, list this matter once again on February 24. So on that date, learned state advocate is requested to apprise us of the status of the matters pending before the Honorable Supreme Court.
Deeply obliged.
হ্যাঁ, যা যা বেলের থাকি সবই থাকবে, এটা খালি ইন্টারিম হবে।
My lord, I am for the petition. My lord, on the last occasion, your lordship was pleased to call for a report, status report from the state.
Position today is fixed for 3:30.
Oh,
My lord, 1 year, 11 months custody.
313 and what was seized?
42 bottles of fancy drink.
Status report filed by the state be kept with the records. Stop. We see that today is the date fixed by the learned trial court for examination of the accused under section 313 CRPC. Stop. Therefore, the trial is on the verge of conclusion. Stop. Commercial quantity of contraband item was recovered from the exclusive possession of the petitioner. Stop. Hence, we are not inclined to allow his prayer for bail. Dismissed. At this stage, tell us, Lagi you.
My lord, my lord, item number 34, Mr. Arun Kumar Maiti is appearing on behalf of the NCB in this case. My lord, he's on his legs in courtroom number 17. My lord, kindly passes an accommodation and fix it on 14, subject to your lordship's convenience.
Next NDPS দিনটা কবে 14 বললেই তো হবে না 15 then 15th
15.
accommodation is sought for on behalf of Narcotics Control Bureau. Paragraph lists this matter once again on 15 retaining his position. 15 January 15 retaining his position.
I'm grateful.
But I appear for the statement.
Well, as per FIR, my lord, the petitioner was going to Sujapur to Siliguri by a public vehicle with the other co-passenger, my lord. And from that bus, my lord, the 754 grams brown sugar recovered from the Shobita Khatun. An allegation that the, my lord, the petitioners and other 1%, brown sugar recovered from the Shobita Khatun, lap of Shobita Khatun. An allegation as per FIR, my lord, the Samima Bibi, this is the petitioner, and Jiaul Haq, guarded by the Shobita Khatun, guarded by the petitioner and Jiaul Haq. That is the allegation, my lord. This is the public bus, my lord. That is the public bus. Shobita Khatun.
From the body of the
Shobita Khatun.
body of
Shobita Khatun. Not Samima Bibi, my lord. And that is a public vehicle, my lord. They also, my lord, were going to, my lord, Sujapur to Siliguri.
This Shobita Khatun is known to you?
No, my lord.
Not known.
No.
Even if known, he will of course say not known. Yes, madam.
Malad, this Shamima Bibi Malad, she signs the Caesar list. When Malad the recovery was made, no objection given there. Then Malad,
There is a police personnel and they forced to sign, my lord.
yes.
So, my lord, there is a lady person, my lord.
She was medically examined, Malad, without police officers. Before the medical officer also, Malad, no statement made towards Malad her non-involvement or that she was just a co-passenger and mistakenly taken away. Malad, they were
Samia Bibi, co-passenger, my lord. My lord, she did not know the Shobita Khatun and Jiaul Haq, my
in fact, Malad.
So 3 accused, Caesar list.
Yes.
How long in custody?
Well, 167 days custody. 167 days custody.
Charge sheet filed?
Not
Charge sheet not.
Then no question. Investigation is still not complete.
Not pressing, my lord. That's even by the in the event of
after full hearing, why not pressing?
my lord, in the event of charge sheet, but not filed, my lord, that
the petitioner
not pressing
says,
this application. So, my lord,
the petitioner says you should have then at the very beginning. It's not fair to her. It's not fair to her if we don't. The petitioner says that she has no involvement in the alleged illegal carriage of commercial quantity of contraband items. Stop. There was no recovery from her. Stop. Recovery was from one
Shobita Khatun.
Shobita Khatun. Shobita Khatun. Stop. Paragraph. We see from the Caesar list that Caesar was made from 3 accused persons, including this petitioner. Stop. Further, comma, investigation is yet to be completed and charge sheet is yet to be filed. Paragraph, in view of the aforesaid and in view of commercial quantity of brown sugar being involved, comma, we are not inclined to allow the petitioner's prayer for bail, comma, at this stage, comma, dismissed.
For the petitioner, my lord. Petitioner is the lady before your lordship, my lord. From one, my lord, from the house of, my lord, from the house of one, namely, my lord, Nimoy Roy, my lord, 41 kgs of ganja has been recovered, my lord.
Lordship, joint possession. Charge frame has been submitted on 13/8/2024.
Sorry.
Joint possession, Lordship. She was there in the house of Nimai Roy,
Yes.
from where the
Caesar list.
contraband has been seized, and this is the Caesar list. Her name is there.
Whose house it was?
House is Nimai Roy's name, and she was there. This contraband is was there with her also.
How long are you in custody?
1 year, my lord. Charge has been framed, my lord. Witness action has not been taken.
11 months is custody.
1 year has
Charge has
passed.
been framed, Lordship. Next date is fixed for evidence of de facto complainant on 15/1/2025.
No,
How many witnesses you have?
20, my lord.
20.
Why do you need 20 witnesses to establish your case?
What is the quantity?
41 kgs of ganja.
41.
Yes.
Lordship, kindly see 153. There is a FSL report, and FSL report is 153, Lordship.
153 kgs.
No. Page number is 153, Lordship.
No, must be
Not
positive.
saying, my lord, positive or negative, my lord.
From joint position, my lord, lordship, contraband recovered, and my
No, he's only on delay.
My lord, the witness section already been
He
started.
not only says there was ganja, various kinds of ganja,
Yes,
various varieties of ganja.
my lord, witness section already been date schedule has been fixed. My lord, 15. Then I have to take the instruction. Then my lord.
Nimai house is there.
My lord.
Yes.
And petitioner is the Anwar Begum.
Yes, my lord, business is going on, my lord.
Please.
Yes,
She is not the relative. Then how Anwar Begum, what is
There, my lord, at the time of Caesar, she was there in the Caesar list. Her signature is also there.
Report, file a report. How many witnesses you propose to examine? The petitioner says that she has no connection with the contraband item that was seized from the house of one Nimai Roy. Stop. She was coincidentally present there at the time of Caesar. Stop. She is in custody for about 1 year. Stop. Beyond framing of charge, nothing has progressed in the matter. Stop. She prays for bail. Paragraph. Let the state file a status report. On the next date, stop. The report shall indicate inter alia, comma, how many of the 20 charge sheet named witnesses the prosecution proposes to examine. Paragraph lists the matter on 15. 15. What were you doing there at Mr. Nimai Roy's house?
My lord, I am not the resident of Sagral PS area, my lord. My lord, this is my unfortunate. My lord.
You should have taken this type of ground.
My lord, the petitioner have, my lord, my 2 child, no, is not involved in this case, but my lord, unfortunately involved.
You should avoid such people who are fond of ganja. You know.
37, I am for the petitioner, my lord. I am covered by your lordship's own judgment, my lord. Idul Mia. My lord, 751 bottles, my lord.
Dates. Arrested?
My lord, arrested on 21st.
But kindly, my lord, I'm praying for not put a
Arrested.
file a
My lord,
report,
may I-
report, because my lord, supplementary charge sheet has been filed. My lord, there is no my lord,
My lord,
copy
I
of-
tender my
State
assistance, my
file,
lord.
my lord.
This is the supplementary charge sheet. My lord, kindly see, my lord. 322 days, my lord, I am in
I have
custody.
not the copy, my lord.
I am covered.
Sir,
my lord.
Your
That regard, I will file
learned
a
friend, learned brother is asking for a day's
My lord,
accommodation.
I understand, but not at the same time, your lordship
That
knows, my
regard, I
lord.
will file a report.
You may be in some difficulty someday. How will you feel if the
Lord, we have to face the client also, my lord. One day is, my lord, your lordship knows NDPS matter again take, my lord.
again Friday?
Very well, my lord.
আমি টপ করে দাও না একটা রিপোর্ট নেবো আমি চার্জশিটটা খালি
He says, what report? If he's relying on Idul Mia, what report? We only need to know when the charge sheet was filed without the FSL report
Long after, my lord,
and when
statutory.
the FSL report was filed with the supplementary charge sheet. If before filing of the FSL report, he exercised his right to obtain statutory bail, that is the end of the matter.
Before received the expert report, charges has been submitted. The charges submitted on 1st July, but thereafter, my lord, supplementary charges has been filed.
When?
But I don't know.
My lord,
That's why I'm.
30/12/2024. My lord, last.
That's why I'm.
My lord, this is the report.
He wants to independently find out on the prayer made on behalf of the state, let this matter stand adjourned for the day and be listed again on Friday date the retaining its position.
আচ্ছা ঠিক আছে দাদা আমি দিয়ে দিচ্ছি হ্যাঁ নামটা
Item 38, my lord, praying for not to definitely.
TD.
May I please, my lord, I'm for the petitioner. My lord, contraband recovered from an abandoned vehicle, my lord. The owner of the vehicle was arrested, my lord.
What was recovered?
41 kgs of ganja, my lord. The owner of the vehicle was arrested. From his statement, another person was arrested. Thereafter, my lord, from the statement of that person, this petitioner was arrested, my lord. He is in custody for 160 days. Charge sheet submitted, my lord. 12 witnesses, prosecution witnesses. My lord, it was recovered from an abandoned vehicle, my lord. As per the complaint, from an abandoned vehicle, the entire contraband was recovered. The vehicle was.
Yes, my lord, that is there, I cannot deny. But my lord, will also kindly consider this is the third case against him. In connection with another case, his bail prayer has been not pressed after hearing this is the order. What has happened, my lord, in that case also, what we have placed is that in another case, there was direct recovery of contraband from him. But however, owing to non-compliance of 42, 50 and 57, he has been acquitted. But my lord, recovery was there on technical ground.
Yes, so far as this case is concerned.
Yes, on the other matter where it was not pressed, there was also only co-accused statement. After my lords had expressed my lords' minds that my lords were not going to allow,
That
it was
time, my
not
lord, the
pressed.
custody period was very little, my lord. The custody
My
period,
lord,
70 days.
co-accused statement that we cannot deny. But this man is habitual offender, my lord, and he
Sir.
Yes, also, whether we will grant.
I'll remain in custody.
That I cannot.
Sir.
Am I off, man?
Sir, when there is no recovery,
My lord.
when it is only co-accused statement made before a police officer, which is not admissible, you have to show something more.
Man.
CDR, money trail, something. Is there anything?
No, man.
Then we'll have to grant.
Hey. I'm only, my lord, emphasizing on his past conduct. That is the habitual offender he is. And all in connection with NDPS.
He's also admitted by.
Yes. Yes.
দিয়ে দাও কুম্ভ মেলা আসছে সামনে. The petitioner says that there was no recovery of contraband items from him. Stop. He has been implicated on the basis of statement made by co-accused persons.
He
Stop.
should appear.
Stop. He is in custody for
160 days, my lord. More than
160 days. Stop. Charge sheet has been filed upon completion of investigation. Stop. His further custodial detention is unnecessary. Paragraph. Learned State Counsel, while opposing the prayer, says that this petitioner has antecedents. Stop. In another NDPS case, he was acquitted on technical grounds of non-compliance with certain provisions of the NDPS Act. Stop. However, in his usual fairness, he does not dispute that there was no recovery of contraband item from this petitioner in the present case, and that he has been implicated solely on the basis of statements made by co-accused persons. Paragraph. Statements of co-accused persons made before police officers are inadmissible in evidence, as has now been decided by the Honorable Supreme Court in the case of Tufan Singh. You remember the reference, citation, na? Tufan Singh to dekhe nite hobe tomake, ekটু দেখে নিও, হ্যাঁ? Stop. We also see that there was nothing was recovered from this petitioner. Stop. The state has not been able to place before us any other incriminating material like CDR or money trail, which would involve this petitioner. Stop. Paragraph. In view of the aforesaid, we are of the opinion that the petitioner has been able to tide over the restrictions in Section 37 of the NDPS Act, and we are inclined to enlarge him on bail.
May it please your lordship. On the last occasion, this matter was adjourned on the score that I submitted before your lordship that one of the co-accused Shombit is on bail, but my learned friend disputed. I took time to reconfirm it, but my learned friend was correct that he is not on bail. I was wrong. Now, my lord, now on the
wrong submission before.
no. Apart from other submissions, but may I? Now, my lord, there are 6 accused persons: Pony, Raju, and Shombit. From these 3 persons, my lord, 1.139 kgs of heroin was recovered. My lord, the 3 other accused persons were Polash, Subroto, and Prashanto, from whose possession, my lord, nothing was found, and they have, out of them, 2 have been granted bail, one by the High Court and one by the learned court, trial court. Now, lordship kindly comes to page 25 of my application for a moment.
Raju Vishal.
No. Raju is a present petitioner.
Yes. How much quantity got from you?
A joint possession, my lord, 1.139 kgs of ganja. We are in custody for 3
Heroin,
years.
my lord, heroin.
I'm sorry, heroin. Heroin. And my lord, 3 years, 9 months, and 27 days where we are in custody. Now, my lord, page on the last occasion, I placed before your lordship page 25 of my application, Supreme Court's order. But this order was, my lord, there are 2 parts in this order. One is, my lord, because of the custody grant of bail, and my lord, second part is, my lord, it has been directed to conclude the trial by 6 months, apart from grant of bail. My learned friend, my lord, disputed this fact, this position, and he said that the Supreme Court, while grant of bail, considered non-recovery and thus granted bail. But I was on a different score, that this is not on the Supreme Court has granted bail, on not on the point of non-recovery, but on the grant of on the custody.
More than 3.5 years.
Now we are in custody for 3 years, 9 months, and around 3 years, 10 months.
And 2 out of 24 have been examined.
My lord, we will only examine, my lord, 10 witnesses.
How many have you examined so far?
My lord, 2 already completed, 3 is going on. And my lord, the Apex Court order, my lord, stress has been given, my lord, particularly when the co-accused has already been granted bail and co-accused is not on the same footing.
Footing has not been considered by Supreme Court.
My lord, kindly see the second paragraph. And my lord, time has been fixed and it will expire on March 2025.
It is an additional.
Why March? 6 months from today means?
Today means, my lord, order dated, my lord, 20th September.
That is correct, my lord. 20th of March.
October, November, December.
My lord. And my lord, another 7 witnesses left.
That is there.
The Supreme Court granted additionally 6 months time to conclude the trial. But Supreme Court has never gone into the merits that whether it was from his possession or not from his possession. Supreme Court was only on Article 21, my lord. My respectful submission is this, my lord.
What is the order of 6 months stand?
My lord, page 25.
Last 25, last line.
My lord, kindly see the second paragraph and the, my lord, last paragraph.
Maybe, but that does not necessarily mean that within the 6 months, one cannot be released if already he has suffered prolonged detention.
Definitely, Your Lordship.
My lord, but grace has been given on the, my lord,
Custody.
only, my lord, considering the co-accused bail.
No, no,
My
no,
lord,
my
that is also one of the reason delay, but my lord, stress has been given, my lord, only on the co-accused has already been granted.
Nah, chalo, Mr. Go. The petitioner says that he is in custody for about 3 years and
10 months.
10 months. Stop. Only 2 out of 24 charge sheet named witnesses have been examined in full. Stop. Examination of PW3 is going on. Stop. Paragraph learned advocate for the petitioner draws our attention to an order dated September 20, 2024, passed by the Honorable Supreme Court in a criminal appeal, in criminal appeal number 3900/2024, carried by a co-accused, namely, Polash Bishash. Stop. By the said order, the Honorable Supreme Court granted bail to Polash, considering the period of incarceration undergone by him, and also considering that a co-accused person had been granted bail. Stop. The Honorable Supreme Court observed that it was expected that the trial court will complete the trial within a period of 6 months from the date of the order. Paragraph. Learned State Counsel, while opposing the prayer, says that the period of 6 months will expire in March 2025. Stop. The prosecution proposes to examine only 7 more witnesses. Stop. It is highly likely that the trial will end within the time period indicated by the Honorable Supreme Court. Stop. There was recovery of more than 1 kg of heroin from the joint possession of 3 accused persons, including this petitioner. Stop. Paragraph. We have considered the rival contentions of the parties. Stop. In our respectful understanding, the observation of the Honorable Supreme Court that the trial should be concluded within 6 months would not stand in the way of the petitioner being granted bail if he has undergone a prolonged period of detention. Stop. We have noted above that the petitioner is in judicial custody for about 3 years, 10 months. Stop. Since the prosecution intends to examine 7 more witnesses, it may not be possible to conclude the trial on an early date. Stop. Paragraph. In view of the aforesaid, we are inclined to allow the petitioner's prayer for bail.
One submission may be recorded. Bail granted to those person, and my lord, this person are not on the same footing.
We have not said they are on the same footing. Have we said, are we granting bail on the ground of parity?
Item number 61, another co-accused, my lord, on the last occasion, my lord said to tag both the matters. Somehow it has not been done. Do I come back at item 61 or?
61 state?
My lord, I will be appearing. 61.
Same as this?
Yes, my lord.
This
person is Pone Biswas.
Yes, Mr. Bishash, same as this Raju Bishash. Recovery from him also. So it will be the same then.
But recovery from him is 413 grams in this petition.
I said, my lord.
More
joint
than
possession.
1 kilo from 3 persons
Yes.
jointly.
Joint possession.
So same order will be here. Same order.
Great report.
I'll just
And same period of detention.
Same period of.
no.
হ্যাঁ
হ্যাঁ।
3 বছর 10 মাস একসঙ্গে অ্যারেস্ট করেছে।
Lordship will just, when your Lordship has passed order, my Lordship will kindly seize. Well, this is which I have highlighted it to the hearing. The highlighted portions are the dates on which the petitioners have taken time. If they are on delay, then your Lordship, the highlighted portions. So many dates. The time has been taken by them. Anyways, I leave it to your Lordships.
Status report filed by the, it's filing this, no? Nina, it is the status report filed by the state, we kept with the records. Bole tarpore ja same order.
Let it be kept on the record. আর কে আমার নামই শুধু দিয়ে বলছো হ্যাঁ কোনটা না পরেরটা তো
না পরে
41
It is there, my lord. Yes.
But no, not activated.
Maybe for
No, sir,
virtual.
sir, we did না ওই এই করবে বলছে লিস্ট
For the list.
লিস্ট ডিসপ্লে বোর্ড
Maybe.
ডিসপ্লে বোর্ড
তাই বল তো আর সিরিয়াল দেখবার জন্য তো লাগাইনি Yes.
My lord, I'm in custody since 23rd of August 2022. Charge was framed on the 21st of January 2023. First examination of witness 14th of July 2023. Till date, that was the last date was 16th of December 2024. Only 2 witnesses, second witness has not been completed as yet.
Out of
15 plus 50 plus during the examination of PW1, there was a supplementary charge sheet filed pertaining to the factum of the CFSL report pertaining to the mobile phone. But within time, the FSL report pertaining to the was done, chemical report. Now, I don't know what latest position there. I leave it to my
report. Esho, approval. The petitioner complains of inordinate delay in progress of trial. Stop. He says that he was arrested in August 2022. Stop. Charge was framed in January 2023.
No, 19th May 2023.
Charge.
Charge.
In May 2023.
Charge sheet in 21. January.
Charge sheet is 21.
No, 21st of January 23.
The charge sheet was filed in January 2023. Stop. Charge was framed in May 2023. Stop. Witness action started in July 2023. Stop. Till the last date, i.e. December 16, 2024, only one witness has been examined in full and PW2 has been examined in part. Stop. He is in, the petitioner is in custody for more than 2 years, 5 months. Stop. Renewal.
No.
Stop. He prays for bail on the ground of. Nah. There are how many charge sheet named?
15 witnesses and 1. 16. 1 is
There
the
are
supplementary.
16 charge sheet named witnesses. Stop. There is little chance of early conclusion of trial. Stop. On the touchstone of Article 21 of the Constitution of India, the petitioner prays for bail. Paragraph. Let the state file a status report explaining the reasons for delay in progress of trial, stop the report shall also indicate how many more witnesses the prosecution intends to examine. Paragraph lists the matter on 15th.
15th is a Wednesday. Your Lordship, Tuesday, your Lordship is taking the NDPS.
No, not necessarily. It's every fourth day. Today is NDPS, then tomorrow is.
Join them. My lord, this case, if I may say so, my lord, has a checkered history. My lord, using a word from Mr. Mohit. My lord, this lady, before your lordship, happens to be an advocate. Now, my lord, she was arrested at Howrah station, where certain articles were found from her possession. Now, my lord, she was in the family way, and in the family way, my lord, she was granted bail, interim bail by a coordinate bench officer. Thereafter, my lord, your lordship comes to page 33. And unfortunately, my lord, the child she gave birth to subsequently died. That's the irony of it. Well, this was the order where your lordship rejected the prayer for extension of interim order and was pleased to, 19th August, and was pleased to reject the prayer. My lord, after that, my lord, I've come before your lordship. And 40.
Yes, sir.
Yes.
Right, my lord, your lordship sees that order, my lord. Now, my lord, please comes to page 51 first.
51. Yes.
Well, please see the report of the chemical examiner of the Customs House lab. Well, the report, the sample under reference. Well, we'll go.
Mephedron.
No, then see. The
Presence of-
presence of cocaine could not be ascertained.
Yes.
If required, then one sees what they say. To send it to TFSL Kolkata or Hyderabad or Sweden. Well, sees the date of this report, well. 20th of October 2023. Well, thereafter, my lord, if your lordship will please comes to page 47. At page 48, my lord, is the results of examination. So, my lord, this was done on the 14th of December 23. That was in October 23. This is the 14th of December 23.
Yes.
Well, if your lordship sees 3 in this examination, 3, item 3, your lordship will see both are not covered under the NDPS Act.
Yes, but 1 and 2 covered.
1 and 2 covered, but not in 12, in 10, 2010-23, cocaine was not found.
Yes.
Here they say cocaine.
Yes.
So, matlab, the result of two examinations,
Yes.
normally, like in postmortem.
No, the customs house laboratory was obviously not confident enough. We can see from the language that we could not detect, but you may please forward it to a better place.
Correct. Now the question is, they specifically said cocaine was not found. Here the cocaine was found. Now, 38 grams and 46.
But mephedron was found by customs lab also. That is covered.
Well, what is there is there. What I'm trying to understand is, my lord, mephedron which was there, mephedron is quantity-wise, it doesn't fall within the cocaine 38. My lord, your lordship has to think it in that perspective. The combination there. And Mr. Kumar doing research, my lord, Gupta, doing research has found out that the Supreme Court has specifically said, when it comes to a combination, what the combination has to be taken away from the quantity which is recovered.
How long are you in custody?
My lord, I'll tell you, lordship. My lord, your lordship, 37 proviso act is applicable to me. Sir, please see 37. My lord, custody, my lord, your lordship, 29th of August 23 to 7th of March 24. I was in custody. Then I was in the family way. My lord, I was given. Then my lord was pleased to take me into custody.
Not to extend from August again.
19th of August. And then I surrendered as per your lordship's order. I surrendered immediately before the lower court. Then still then, my lord, I'm in custody. My lord, 332 days I'm in custody.
No, 37 proviso.
Yes.
NDPS Act.
Yes. I did. Well, I think I'm growing old. Oh, sorry, Manu. That was 45 of the CMLA. Sorry, Manu. I was thinking about the lady part.
Yes, what is this? What is the stage?
But first of all, my lord, let me address your lordship.
Have you concluded, Mr. Mukherjee?
Yes, let me hear him, then I can give a reply.
My instruction is that, my lord, she is not an advocate. She was a floor performer here at
Irrelevant.
The second point, my lord, your lordship has dealt, my lord, when it was found 86 grams of mephedron, what my learned senior friend is showing. My lord, there are two seizures. The first seizure, which was from her, and the other co-accused Mahesh from Kolkata, from the platform, it was sent to customs. Subsequently, during the investigation, there are subsequent seizures made from other co-accused persons who were also arrested. Those were sent to CFSL. That is why 1, 2, 3. My lord, mephedron was found. The official gadget, my lord, it shows mephedron, which is a controlled substance, and that's why the commercial quantity, intermediate below commercial quantity is 50 grams. So that's why the bail application was rejected. In the new act, mephedron has been considered as the narcotic substances. My lord,
new act meaning amendment.
Notun amendment.
When was that amendment done?
Now, mephedron has been considered.
No,
when was that
amendment done? I just want to see that. It can't be, my lord. Article 20 is a bar. 21 is a bar.
May I say this? But on the last occasion when it was
November, কবে? আরে ওটা
বার করে
জানতে চাই।
দিচ্ছি, বার করে দিচ্ছি স্যার, এক্ষুনি বার।
তুই রেগে যাস না,
না, না,
তোর
স্যার।
হাতে সব ক্ষমতা। কবে হচ্ছে? তুই amendment-টা দেখ না বেটা।
এই তো with effect from 5 to 2015.
হ্যাঁ
স্যার, এটা তো 5 to 2015.
কি?
আপনি
দুটা।
মেফেড্রন ঢুকেছে কিন্তু।
হ্যাঁ।
Mentioned in the notification of
5 to
50 grams.
15. Yes, 50 grams. Here 86.
See the list. And next, I'll show your lordship. Now, let's go into the merit.
Complete.
Acha, let him complete.
Let me show the season list.
Please show the season list. I have annexed it, brother.
38 grams plus 48 grams of 38 and 48. And they have even mentioned the same in their averments in the petition. They have mentioned the same, that it has been seized from her. It is mentioned in their averments in the petition also.
This is Miss RC Supreme.
Yes.
And two.
এটা কোন ডেটটা বলতো? Well, which is the date of that Caesar, my lord? 29th or
29.
29th.
Yes.
Yes, 29th August.
My lord, now see number 2. Please comes to number 2 first. There. Seize, my lord. Where it will seize?
Yes.
From the platform.
And Dara, no, not from the platform.
From where? Place of Caesar.
See, my lord.
In the office room of Howrah GRPS.
Yes. Not from the platform 18. Please, let me.
Sir,
At
sir,
least,
sir.
Mr.
Sir,
You are
sir.
also an accused person's lawyer. Now, my lord, so that is first. Secondly, my lord, please come at the bottom 5.
After we refused to extend the interim bail,
Yes.
did she further approach us, or this is the first time?
After that, the first time. Thank you.
Did the co-accused approach us for bail? No.
The
Could be.
my lord, may I say this? The co-accused.
110 we have passed this bench passed an order 110/2024.
In respect of another
Vice
question.
Prasad Jaiswal, second accused.
My lord,
Did not go through.
Mahesh Prasad.
Okay.
Mahesh Prasad.
Well, it was yes, we have rejected Mahesh with a detailed judgment.
Yes. Because Mahesh
Considered
and
it.
Asti were both caught together.
Now, my lord, another thing, man, I was thinking I'm becoming so dull. My lord, more than a tube light I've become. I think I was making some mistake somewhere, my lord. No, your lord just said it. I'm not going to see it. My lord, I was saying about, yes.
No.
My lord, please comes to. My lord, the only difference is, my lord, she's a lady. Number 1. My lord, please come to 36C of the NDPS Act. My lord, comes to section 36A first. My lord, comes to section 36A. My lord, has my lord got it, my lord? 31 capital A, small c.
36.
Yes, my lord. 36 of the NDPS Act, my lord.
Offenses 36A.
Yes. Offenses tried by the special. Now comes to 3. Now, will please read 3. Nothing contained in this section shall be deemed to affect the special powers of the High Court regarding bail under section 439 of the Code of Criminal Procedure, and the High Court may exercise such powers, including the powers of so-and-so. So it is a power which is given to your lordship under the Act itself. Now, my lord, why I had said about the lady, why was it troubling me was, my lord, under 439, there is a general power. 437 has a limitation. 437 has a limitation, but the proviso relates to a lady. Under 437. Now, when it comes to 439 power of your lordship, then the question comes before your lordship is, 439 has no, what should I say, embargo, if I may use the word, or a bar to your lordship granting bail in any offenses without even giving a notice to the public prosecutor. That's 439. Now, the law, when it says nothing shall be deemed to affect the powers of the High Court, whether 37 will overrule 439 or whether your lordship, apart from 439, your lordship's Article 21.
So huge power of High Court is
That is what I'm trying to say. The power of the High Court to grant bail,
unlimited.
And that's my reading of the situation. I may be wrong, but I have to think new. No, man. If your lordship feels I'm
on the ground of these ladies, that's why you are.
That is only the reason why I'm trying to bring it to your lordship's notice. Maybe, I am not talking sense, but I think, there is some sense in this.
You did not allow him to speak.
My lord, what I have shown, my lord, your lordship has rejected.
He has only shown August, it has been rejected. Now, what is the progress after that? That let him give after that.
There is no change of circumstances, my
Arey,
lord.
no,
My
no,
lord, since
progress.
August 2024, since your lordship has rejected RC Siddiqui, post that Mahesh's bill was also rejected by your lordship.
Now, what is the stage of the
My lord, next date is on the 7th of February for production. For framing of charge, sorry. For framing of charge.
Why so?
It's this is a case. My lord, then the first date was on 20th. Where the magistrate was unavailable.
These are the order sheets, sir.
No, 27th February. And 20th was the last date. It couldn't be done because the magistrate was ill.
No, there is no PO. What the order sheet দিলাম আমি?
তো তার জন্য
Mala, for 3 days the PO is not there. See, man, I've given the
what
order
we
sheet.
can-
Transferred.
Maybe must your lordship will know it why.
How many witnesses are there in the charge sheet?
Mala, 33.
1 year already in custody.
Lord, may I
Not
say-
1 year.
Nearly, my lord. 332 days exact. Time up হয়ে গেল।
Lord, may I say this? Well, the investigating officer is here. Well, this is a huge racket of organized crime.
Mr.
But it was-
Vishwash, normally what we do, we call for a report saying how many you propose to
Your lordship
examine,
so directs, I can produce a report also.
so that we can get an idea. You may not be examining 33 witnesses.
I'll produce a report if your lordship so
The
desires.
petitioner says that even charge has not been framed. Stop. She was initially in custody. Stop. Then she was granted interim bail by this court. Stop. Since 19 August 2024, again, she is in custody since this court.
Well, 19th, the lordship passed an order, gave me 10 days to surrender. I
I-
surrendered on the 29th.
Since 29 August 2024, 19 now, 29. She is again in custody, having surrendered in terms of this court's order dated August 19, 2024. Stop. Paragraph. Now, she says that there are 33 charge sheet named witnesses. Stop. There is,
Charges have not been framed.
সেটা বলে দিয়েছি. There's no possibility of early conclusion of trial since trial has not even started. Stop. Paragraph. Let the state file a status report on the next date explaining why charge has still not been framed. Stop. The report shall also indicate how many witnesses the prosecution intends to examine.
Malan, may I say one thing? Malan, don't take me otherwise. What is the purpose then, if they can do it with 22 witnesses, what is the purpose of sending 33 witnesses?
We don't understand also.
But I don't understand. I really don't understand. Now the PPs come and say, the IO has said, I can do it within 22. What's the point of 33 then?
Absolutely right. Absolutely right. So
But
there's,
Malan, I think
there's something common between you and us. We both don't understand.
yes, that's true, Malan. Malan, great men think alike. Fools seldom differ. We come out of the second category. Well,
Oh, হ্যাঁ, list কবে হবে? 15?
now 15 একটু পরে কর।
আচ্ছা, what is the next date?
February.
ও বাবা, সে তো অনেক দূর।
Malan keeps it on 15.
15.
Let us see what Mr. Bishwas brings to the court. এটা আবার কি হলো?
একটা মেনশন করবো হসপিটালে ভর্তি হয়ে গেছে
কি হলো?
my lord in compelling situation my lord I'm mentioning my lord the present petitioner is admitted in hospital my lord from the jail authority they have messaged the relative my lord this condition is not good therefore my lord kindly upgrade this matter my lord this is the medical document sent to
When did you get this document?
my lord on first he was admitted then my lord they immediately they have my lord sent to the relative prior to that in
Sent when?
my lord the first my lord first of
First, today is
today on 7th my lord
grave urgency.
my lord he is
One thing for the information of all learned advocates, you can spread the word. Tomorrow, this bench will sit continuously till 2 o'clock. Thereafter, it won't sit. It's because of my personal unavoidable reason. So since I won't be able to be there after recess, we thought we'll just continue till 2 o'clock. And then this bench will not be there tomorrow. Kindly spread the word. So your tiffin will be delayed. That's it.
My lord, only one thing, my lord. In respect of item number 14, my lord have directed to meet the petitioner, one of the STF officer, my lord. So I have given the name of one person, but my lord, he is from narcotic cell, detective department. My lord, kindly make it OC STF PS.
এই item 14 কে নিয়েছে আমি জানি না তুমি দেখে নাও কি বলছে
I have police station. No, 112 Dupont Street. Man, deeply up.
Lord, in this matter, what happened, my lord? Yesterday, my lord, the date was fixed for trial, my lord. That information or the report which we have got, that information is missing because, my lord, if your lordship kindly gives us another time to include that.
He's lying vacant, madam.
Huh?
PO is on leave. Yes, madam, tomorrow is the date fixed for recording evidence, madam.
Tomorrow?
Yesterday, 6th of January was fixed
Yesterday.
Yes, start
my lord,
date.
So what your learned friend is saying, he'll keep it on Friday, he'll come back with the latest update. Is that all right? Learned advocate for the state says that yesterday, bracketed Tariq Tadao, was fixed for trial of the matter. Huh? Stop. On his request, comma, let this matter be listed again on Friday data the when he shall apprise us of the latest status of the trial. Are you wearing a new pair of frames, glasses?
my lord, I used to, my
Keep
lord,
on changing.
alternative, yeah, yes,
How many dozens you have?
no, only 3.
Only 3.
Lordship was praying for not this week, your lordship. 44. Great.
Item 45.
My lord, item number 45. I'm for the petitioner.
Possible.
My lord. Only one point, my lord. Section 42, subsection 2, my lord. Non-compliance of section 42, subsection 2. No intimation was given to the superior authority, my lord. I'm relying a judgment of the coordinate bench of this honorable court, my lord, circuit bench, my lord. Your lordship was the part of that bench, my lord.
This is contrary, this is wrong order. Contrary to Supreme Court. This should be thrashed out at the trial.
But my lord, the section 42, subsection 2, it is a mandatory in nature, my lord. And non-compliance of section 42, subsection 2, my lord.
Non-compliance is a question of fact. That factual issue will be thrashed out at the trial. You may, if you are convicted, you may well be acquitted for non-compliance.
My lord.
Or I mean, in the appeal. But now the Supreme Court's view is these are all factual issues, Taito.
And now another point.
If that is the only point, then sorry.
My lord, that no witness was there at the time of search and seizure. And
video?
No, my lord. Perhaps video was not there.
No, we don't know.
Specific mention in the FIR of video, my lord. That is also one of the violation of the order of the coordinate bench of this honorable court. And my lord, in maximum time, what happens, my lord, in NDPS cases, in our West Bengal.
How long are you in custody?
My lord, I'm in custody, my lord, 1 year, 5 days.
My lord, seizure from his house, and he has been arrested from his house. His signature is on the seizure list.
What was recovered?
My lord, 520
520
bottles of
fentanyl.
codeine phosphate.
Sole accused.
So like no, my lord, there is another accused,
Another
but
my lord, my brother, he has been granted anticipatory bail by the coordinate
from
bench
his
of this
position nothing has been
officer.
so his name
Till date, my lord, charge has not been framed.
How many witnesses?
My lord, 8 witnesses. My lord.
Then, I mean, charge not framed, 1 year, 5 months in custody, Mr.
5 days. 1 year, 5 days, my lord.
5 days.
Yes, my lord.
Very well, 1 year.
Yes, my
What
lord.
a
No progress.
My lord,
brief period of
my
time.
lord, we have received the FSL report and thereafter, my lord, date fixed for framing of charge is 14th of this month. My lord.
No, Mr. Akram, immediately we are not inclined.
Exclusive motion.
Issue.
My lord, 14th is fees, my lord, kindly seize that date if.
What you will see, you want to see what charge is framed?
Yes, my lord.
What's it?
ঠিক আছে, 14th. 15th we'll keep it.
My lord.
No, 15th you may not be able to gather information. If 14th is the date, then we will keep it on 20th. 20th. The petitioner says that he is in custody for more than a year. Stop. Charge is yet to be framed. Stop. There is non-compliance with various provisions of the NDPS Act, including Section 42(2). Stop. Also, comma, the search and seizure process was not videographed as per the direction in the case of Kalu Sheikh. Kalu Sheikh, give the full name
My lord, I see.
and the reference. Paragraph learned state advocate says that January 14, 2025, has been fixed as the date for consideration of charge. Stop. Both the learned advocates say that the matter will be listed after January 14, 2025, so that the latest status of the trial can be placed before this court. Paragraph lists this matter once again on January 20, when the state shall file a status report, which shall indicate, inter alia, how many witnesses the state proposes to examine.
Grateful, my lords. देखिए
Or the petitioner is in custody. Petitioner is in custody for 2 years, 3 months, 10 days. My lord, earlier rejected by the Honorable Court in September 2023. On 8th January 2024, charge was framed. Thereafter, 11 dates have expired. None of the witnesses have come to the witness box. And Lord, kindly see the orders I have attached with the petitioner.
File a report. 2 years, 3 months, 10 days.
Yes, on 11 dates, none of the witnesses have come.
10th is the date fixed. 10th of this month.
We'll keep it beyond the 10th, after the 10th. The petitioner complains of inordinate delay in progress of trial. Stop. He says that he is in custody for 2 years, 3 months, 10 days. Stop. How many hours? Acha. Stop. He says that charge was framed on
8th January 2024.
January 8, 2024. Stop. Thereafter, 11 schedules were fixed for examination of witness. Stop. However, witness action has not yet begun. Stop. Paragraph. Let the state file a status report explaining the delay in progress of trial, if it can. Stop. The report shall also indicate inter alia, how many how many charge sheet witnesses?
On instruction 12.
How many out of the 12? charge sheet named witnesses, comma, the prosecution intends to examine. Paragraph lists the matter. Now, we are told, paragraph we are told that January 10, 2025,
10th and 13th, my lord.
January 10 and 13, 2025, are the next dates fixed by the learned trial court. Paragraph list this matter either 15 or 20.
15.
January 15.
Yes.
To be
47.
47 and 48 না
সেম মামলা নাকি?
না দুটো মিস করে গেছে
দুটো সেম মামলা?
না But 47 and 48 mal I'm praying for not to do only mal. But
if we don't grant you not today and grant you NTD, will that do?
well 5 days.
Then 49.
Lordship, item number. না না আমি 49
ওই আসাম নিচে আসাম নিয়েছ ওই নাম্বারটা কথা সকালে যেটা বললাম 50 আই এম ফর কি আছে রে ওইতে
না না 49 ফোনে
কি করবে?
Lordship, item number 49 praying for not to do. Grateful, Lordship.
50. 50 not plus 4.
the 21C of the NDPS Act, my lord. I'm in custody for my lord 92 days. My lord, yes. My lord, now my lord, in this case, what has happened, kindly see.
Has been submitted.
No, my lord, I do not.
No, investigation is not complete.
Kindly see, my lord, on basis of the co-accused statement, my lord, I have been implicated.
Very investigation period is still remaining. If you proceed further, we won't even allow you to withdraw it.
That is what I was just telling my lord.
Then, my lord, let me take some.
Not plus 4. Not plus 4.
Are they not press me?
Okay. Not plus 4.
Hmm.
51.
Well, in this case, my lord, I am relying on the case of Idul Mia. In this case, my lord, the petitioner was arrested on 25th December 2023. Yes. Yes. 25th December 2023, he was arrested, and charge sheet without FSL was filed on 21st June 2024. That is on 179th day. I preferred statutory bail in the court bill on 8th August 2024, and that was turned down. And that is on 227 days. Now, FSL report has been filed before the trial court on 4th November 2024.
Mr. Kesari.
Now in custody, 1 year, 13 days.
This is again squarely covered. What to do? Interim bail.
2110 was the supplementary charge sheet.
2110.
Yeah, 2110.
But he says 4th 11.
24. He's in custody since 23.
23.
No, no.
December 23.
He says that FSL report was filed on 4th November.
4th November 2024, before the trial court.
12th November.
Anyway, makes little difference. Makes no difference really. Only for the issue. The petitioner says that he was arrested on December 12, 2023. Stop. The charge sheet was filed on June 21, 2024, i.e., on the 179th day after his arrest, but without the chemical reports. Stop. After expiry of 180 days from the date of his arrest, he applied for statutory bail on August 8, 2024, since the charge sheet was incomplete, not being accompanied by the chemical report. Stop. His application was rejected by the Learned Trial Court on August 8, 2024. Stop. Hence, the present application was filed when
Present application before your lordship was filed
On 22nd day of November 2024.
on November 22, 2024. Paragraph. Learned State Advocate says that the FSL report was filed along with supplementary charge sheet. Do you have the date, Mr. Kestri?
Yes, we have the date of the supplementary charge sheet, Mala. That's the 25th of October 2024.
On October 25, 2024. Stop. What is the stage now?
Stage is
Charge framed?
No, not yet.
However, charge is yet to be framed.
it's for production.
Is yet to be framed. Paragraph. We see that although the charge sheet was filed within the statutory period of 180 days, the same was not accompanied by the chemical report. Stop. In the case of Idul Mia, etc., citation Deve, this bench held that such a charge sheet is an incomplete one and is not a charge sheet within the meaning of the provisions of the CRPC. Stop. Hence, upon expiry of 180 days from the date of the petitioner's arrest, a right to obtain statutory bail accrued in favor of the petitioner. Stop. Prior to filing of the chemical report before the Learned Trial Court by way of the supplementary charge sheet, the petitioner exercised such right of obtaining statutory bail by applying before the Learned Trial Court on August 8, 2024. Stop. Learned Trial Court ought to have allowed the application. Stop. However, the application was rejected. Stop. Hence, this present application, paragraph, it is now fairly well established that once a right to obtain statutory bail accrues in favor of an accused, and he exercises such right by making an application before the appropriate court, subsequent filing of the charge sheet or FSL report cannot affect such right. Paragraph. In view of the aforesaid, we are constrained to allow the petition. We are inclined to grant interim bail to the petitioner. Stop. We do this keeping in mind that the issue as regards whether or not in an NDPS case, the chemical report must mandatorily accompany the charge sheet, is pending consideration before the Honorable Supreme Court. And in all cases touching this point, the Honorable Supreme Court has been pleased to grant interim bail to the accused person. Paragraph. Accordingly, interim bail usual condition. Next, this order of interim bail shall continue till the end of February, 2025, or until further order, whichever is earlier. Next, list this matter once again, February 26. No, after 20, 26. On that date, Learned State Advocate is requested to apprise us about the latest status of the matters pending before the Supreme Court.
My lord, item 52 paying for not today, my lord.
Take please, your lordship.
The petitioner is in custody for 2 years, 8 months. And the fact remains, that the charge sheet was submitted on 170th day, 170th day.
169th day.
Without, my lord, FSL report. And then, my lord, it continued, trial commences, charge framed, 2 witnesses were examined. Then I filed this application. And one intervening period when the bail application was filed on behalf of the petitioner, that was turned down. And since then I am in custody. I am continuing in custody after filing my application. Very recently I am told, but because I have entered the order sheet where it will not reveal that a supplementary charge sheet was submitted intervening period. And I'm probably it have not yet reached the hands of.
Why are you speculating, Mr. Roy? Let us call for a report.
My lord, on 2nd December.
Report has filed.
No,
my lord.
My lord, the last occasion,
Lordship was
took time, my lord, it was on the understanding.
to obtain instruction, my
To
lord.
obtain instruction. He has taken the instruction.
You did not. My lord, I have obtained the instruction. My lord, the lordship said that only obtain instruction, that will be enough. My lord, the FSL report was received on 2nd December 2024, and the supplementary charge sheet was filed on 12th December.
12.
These are the facts.
When were you arrested?
But I was arrested on, my lord, 30th December 2022.
When was the charge sheet filed?
But the charge sheet was
17th June 2023.
When did 180 days expire?
My lord, after, my lord, 17th July 2023. 17th July
No.
2023.
No.
It will be sometime in June only, after a few days. On
Yes.
169th day it was
Correct,
filed.
correct.
Another 11 days.
You are worse than mean arithmetic. 170th day, 17th of June. Then 180th day will be 17th of July. Sometime 28th of June or something like that.
Special report submitted.
Then when did you apply for bail?
My
You know,
lord,
the
on
trial court.
22nd April 2024.
So that was before the 180 days expired.
No.
Yes, before.
20th April 2024.
23. Yes, what?
Order number 30. My lord, your lordship will produce from the order sheet.
Did you mention that you were applying for statutory bail because FSL report is not there?
Application was not with me, but it is not. Your lordship knows. Your lordship.
You are asking as a matter of fact.
that
You
is
don't
that.
know. ठीक আছে.
But it is, my lord, order number 30. Your lordship will find.
So therefore, sir, they applied before you filed the FSL report. It was squarely covered again. Hey, the petitioner was arrested on December 30, 2022. Stop. The charge sheet was filed on June 17, 2023, but without the chemical report. Stop. 180 days from the date of the petitioner's arrest expired sometime towards the end of June, 2023. Stop. The petitioner applied for bail on April 20, 2024.
April 22.
20?
22.
Huh?
2024. Order number 30. Your lordship.
22.
24.
April 22, 2024. April 22, 2024. Stop. The application was rejected by the learned trial court. Stop. Hence this present application. Paragraph. Learned state advocate says, on instruction, that the chemical report was filed, was filed along with supplementary charge sheet on December 12, 2024. Stop paragraph. We therefore see that the charge sheet, although was filed within the statutory period of 180 days, did not have the chemical report with it. Stop. Hence, going by the decision in the case of Idul Mia Diye Debe, upon expiry of 180 days, the petitioner became entitled to statutory bail. Stop. He exercised such right by approaching the learned trial court on April 22, 2024. Stop. Once he exercised such right, subsequent filing of chemical report would not affect such right. The paragraph, hence, we are constrained to grant, and hence we are inclined to grant interim bail বলে তারপর যা আছে অন্যটা সেম করে দেবে আগেরটা যা ছিল বুঝেছো it will come on the 26th of February.
26th February.
Bail is till the end of February or until further order? ওই পুরোটা দেবে সুপ্রিম কোর্ট ফোর্ট যা যা বলি ওগুলো সব দিয়ে দেবে
For the petition. From co-accused person, contraband article was recovered. Petitioner is in custody for 110 days. No recovery from the petitioner.
Hey, statement.
No recovery.
Statement छोड़ के.
Yes, Mr. Kesri.
Co-accused.
Co-accused. No CDR, no money trail. These
Statements that they were in. Oh, CBI.
charge sheet filed.
Charge sheet file.
Filed.
Charge sheet. Oh, charge sheet not yet. Not yet.
Investigation
Not yet. Then they were call records with other co-accused persons.
Sir, maybe, but they still have 70 days to investigate. God knows what they will find. We don't know. We are not the investigating agency.
Well, let me come back after that.
After?
Fetching this application.
We'll say this. Since charge sheet is yet to be filed and investigation is not complete, we are not inclined to entertain the prayer for bail. Stop. At this stage, learned advocate for the petitioner says that he is not pressing the application. Dismissed. No, don't say Idul Mia. Idul Mia.
Till date, my instructions, till date, CFSL has not yet filed.
Not yet filed. Give the dates. Date
of incident, my lord, 8/3/24. Date of arrest, 8/3/24.
8/3/24.
My lord.
Arrest.
Charge sheet filed on 23/8/24.
23/24.
168th day.
Yes.
180 days expires on 4/9/24.
4/9/24.
He prays for bail on 9/9/24, which gets rejected.
And CFSL.
Not yet ready.
Assume.
No, it is the file behind.
The petitioner claims that he has been falsely implicated in this case. Nothing has been recovered from you.
No, recovered, my lord.
Petitioner claims that he has been falsely implicated in this case.
478 grams of heroin.
The learned counsel for the petitioner has submitted that till date CFSL report is not filed. Is not filed now, is not submitted before the learned trial court, and as such he is entitled to the benefit of the judicial decision reported in Idul Miyar Telecast. Stop. He has been arrested on 8/3/2024. Charge sheet was submitted on 168th day of his arrest, that is on 23/2024. Stop. The statutory period of 180 days has expired on 4/9/2024.
180 days.
180 days. His bail prayer was rejected by the learned trial court on 9/9/2024. Stop. Para. The learned counsel for the state opposes the prayer for bail. However, he has fairly admitted that he does not dispute. He does not dispute that the FSL report has not yet been submitted before the consent court. Stop. Para. We have considered the materials on record. Stop. It appears that the petitioner was arrested on 8/3/2024, and though the charge sheet was filed within the statutory period, but till date no CFSL report has been submitted before the learned trial court. Stop. In view of the judicial decision of this bench reported in such as such, the petitioner is entitled to claim the benefit as envisaged in the said decision. Stop. Accordingly, we are inclined to grant interim bail to the petitioner on certain conditions. বলে ওই যেটা হয়েছে ডেট ফেট সবগুলো একই হবে, ঠিক আছে? ওকে।
তার আগে বাবা ওই সুপ্রিম
Interim bail মানে
এইগুলো সেটা
পেন্ডিং আছে সবই ইন্টারিম দিচ্ছে
interim bail
interim bail
27
26th
26th
February.
date মানে
মোটামুটি ঠিক আছে এইগুলো
Idul Miyar, but if I am not wrong, this is the first case where my learned friend opened this issue. At that point of time, your lordship rejected his contention, but still FSL report is not on board.
Let me file a report then, because it is not here. Charge sheet has been filed, but I couldn't find. File a report, Miller, whether that has been filed or not, whether it has been filed.
You're in custody for?
I am in custody for 1 year, 1 year, 3 months.
Devajyoti.
But the order sheet says so.
Learned advocate for the petitioner says that although the charge sheet was filed within the statutory period of 180 days, comma, the same was without the FSL report. Stop. According to him, comma, till date, the chemical report has not been placed before the learned trial court. He is in custody for?
1 year, 3 months.
Trial has started. Charge not framed.
Charge is not framed.
Stop. Charge is yet to be framed. Paragraph. Learned State Counsel seeks a little time to file a status report. Stop. Let such report be. Stop. Stop. The report shall indicate the reasons for the delay in progress of trial, as also the number of witnesses that the prosecution intends to examine. Stop. The report will clearly indicate whether the chemical report along with supplementary affidavit has been filed before the learned trial court, and if so, when. Paragraph 15th.
No, 15th.
15th.
Little time. এত তাড়া কিসের তো?
জেল থেকে বেরোনো তাড়াতাড়ি
হ্যাঁ
Lord, in 57, my lord, I am for the petitioner. Lord, I am praying for bail for non-completion of the investigation within the period of the 180 days and the submission of the charge sheet, my incomplete charge sheet, my lord, within the, my lord, the 180 days, my lord.
Incomplete meaning?
Incomplete means, my lord, I am coming to your lordship, my lord, because, my lord, the IO himself, my lord, filed a prayer for extension of time under section 36A subsection 4 of the NDPS Act, but which itself, my lord, says that, my lord, can you see, my lord, page 5 before lordship brief, my lord, I have quoted the provisions, my lord, of the section 36.
We are a little aware of
Yes,
the provision.
yes. My lord, when the, my lord, can you see, my lord, language, my lord, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year. Well, can you see, my lord, my application, my lord, page 48. 47. 47. Page 47. That is the, my lord, charge sheet. Now, ठीक है. Last but one subparagraph. A separate period under section 36A(4) of the NDPS Act has been here being placed before your honor for continuation of the further investigation of the case and collection for further evidence against the all accused persons. Well, that was the prayer. Because, my lord, the IO knows very well that the investigation is not complete. That is why, my lord, on 23rd of August, he made an application before the trial court for permission to interrogate one person, namely, my lord, Nios Daga. And that prayer was allowed.
Where extension was allowed?
Yes.
No.
Yes, yes.
Nothing, my lord. Extension was not allowed, my lord. Extension cannot be allowed, my lord, because, my lord, there was not the report, my lord, of the learned public prosecutor.
Public prosecutor's report is here.
Yes. Public prosecutor report is required. And, my lord, the
PP's report is there.
No, no,
36A4 talks about the PPs.
My lord,
Prayer for
let him complete, my lord.
but according to my hobby submission, my lord, in view of the provisions of the, my lord, the section 36A, but the investigation was the 36A subsection 4. Investigation was not complete because, my lord, the IO himself under prayed for extension of the time. Though, my lord, there is no prayer, my lord, there is no.
when you were arrested.
My lord, I was arrested on 12th January 2024.
Yes. 180 days complete when?
When, my lord, on 10th July 2024.
10 July 2024.
Yes.
Charge sheet submitted when?
Charge sheet was submitted on 10th July 2024.
So on
180 days. Only to, my lord, avoid the, my lord, provision of the 180 days, my lord, so that I can detain in the custody, my lord, more.
So extension of prayer should be made by the prosecution on at least on 10/7/2024. Is there any petition from public prosecutor?
No, no, my lord. What happened, my lord? Your lordship will see the initial charge sheet was having the FSL report. So, my lord, there is no question that it's an incomplete investigation. My lord, your lordship will see in the initial charge sheet, the FSL report was on board. Now, my lord, the extension prayer was on the ground that, my lord, the go down from where this, my lord, the 7,500 bottles of fentanyl was recovered, my lord, in front of a go down, where, and from the spot, this petitioner was arrested. Now, the owner, to determine the ownership of the go down, my lord, the prayer was made because, my lord, there is a allegation that one of the co-accused person has forged signature and made a fabricated, my lord, leave and license agreement. And, my lord, for that, to get the QEBD, my lord, document from the concerned FSL, my lord, that prayer was made. But so far as the, my lord, FSL report is concerned, my lord, there is no doubt. It was on board within 180 days. So, my lord, it cannot be concluded as an incomplete, my lord, charge sheet. And that is the, my lord, I have handed over the order. My lord, your lordship will see the order where, my lord, in very detail, the learned trial court has decided the issue that no indivisible right was accrued to him. Why, my lord? That is the order, my lord.
Order, which page?
My lord, I have handed over the first page. From the first page, your lordship will see about 5-6 pages order. Detailed
I want to
rival submissions were recorded, and my lord, it was held that no indivisible right was accrued because the crux of the case, that is, it is contraband that was established within 180 days. Now, whether the ownership of the godown, that is a, my lord, ancillary thing, my lord.
So, he has a point.
No. My lord, FSL is not the all thing of the investigation. My lord, investigation means the culmination of the materials collected during the investigation. But so far the IO of the section 36A subsection 4, that my lord says that the investigation is not complete. Prayer is my lord under section 36(4)A. IO himself, my lord,
leave it. Till 180 days, there is sufficient evidence, material showing that contraband articles are recovered, and FSL report shows that positive narcotic.
Yeah.
So, till 180 days, there are sufficient evidence against you.
But
that is it. We brush aside that period thereafter. Till date, 180 days, there are sufficient materials. We are inclined to.
No.
And he is not in custody for not even a year.
But examination also, my lord, the Niwas Daga, my lord, for which, my lord, for whom examination was. Niwas Daga, my lord, the siege was made in front of her, my lord, go down. It is also the, my lord, includes the, my lord, material. My lord, he was not examined. My lord, that is why, my lord, the IO prayed for, made the application before the learned trial court for a permission. That is why, my lord, the investigation.
How long are you in custody?
Not even a year, man.
Not even a year.
About 1 year, 362 days. 362 days I am in custody.
Yeah.
But kindly, my lord, one thing. But so far, my lord, the findings of the learned judge is concerned, my lord, trial court, my lord, before whom, my lord, I prayed for, my lord, statutory bail for, my lord, non-completion of the investigation. I want also want to argue on that point. Because, my
you want to seek adjournment today?
No, my lord, nothing.
Lord,
I
that
want
was
to
like there is a revisional jurisdiction.
That will take some time.
Okay.
It will be argued before a revisional jurisdiction for subject to correction.
Can you fix a date?
We'll fix it on a Saturday.
That
Yes. Bail matter will take some time, you are saying.
no, my lord, take some time, my lord, that not that they have entered date.
How long? How long will you take?
15 to 20 or 30 or 30 minutes. my lord.
Started with 15 and ending up with 30. Tell us 15 minutes or 20 minutes or how much? How long?
30 minutes maximum. Can you fix a date, my lord? I don't know.
শোনো এদিকে এসো হাতাটা আনো
দেখি বুঝে হ্যাঁ
clock.
order লিখে দিই
Heard learned counsel for the petitioner as also learned counsel for the state, comma, at some length, stop. Paragraph, learned counsel for the petitioner says that he would like to advance further argument on the point that the petitioner is entitled to default bail. So he further candidly says that it may take, his argument may take a little time. Paragraph lists this matter once again on January 17, 2025, marked 4 p.m.
One thing, my lord, on that day, my lord, if the court, my lord, does not sit, my lord, up to 4 p.m., then, my lord, on the next day, my lord, after at court.
On the next day,
Saturday, sorry.
on the next day, Saturday, yes, yes.
No, sorry. On Monday, sir, but
We will see.
because my lord, there is something or 3:30 or something, my lord, that is something.
Why you resist it?
17th की बात.
My lord, I have no right or power to resist that.
No, Friday, usually probability of 3:30 is extremely high.
Kindly, my lord, make it on Monday, my lord.
Pray very hard for everybody's good health.
ঠিক আছে, all right. অবস্থা বুঝে ব্যবস্থা বুঝে চলো।
May I get back the order sheet? Malad?
Yes, yes.
আচ্ছা, চলো।
হ্যাঁ,
Not today, not today.
করবেই না, ডাকো না।
Not to them.
I'm for the prediction report. Same ground. I'm also taking the ground of Interim.
Still not submitted.
Still not submitted, right?
This is the report, Malad.
Yegulo, tarikh-gulo, give us the dates.
My lord,
The dates
date
will
of
be
occurrence 29/9/2023,
Arrest.
arrest 30th.
30th, 30/9/2023, charge sheet 21/2/2024,
21,
21/2/2024,
180 days,
charge framed
180 days.
180 days
March.
for
It comes in March.
Yes.
will be 29th of March 2024.
Then when did you apply for bail? Rejection.
I did not. Now the charges have been framed also on 21 on
Did not.
15/4/2024.
Treat this. এখনো তো charge sheet file হয়, মানে FSL file হয়। We'll treat
I'll
this
tell you
as.
CFSL report is not on board even today. So
Therefore,
that's the difficulty.
we'll treat this as
This application perhaps will now be
treated as.
has to be.
Esho,
My lord,
he is arguing your case.
merit wise also I have a very good. Though I do not sell them.
Merit-wise,
Then don't take the point of Idulmiya.
merit-wise, then Malad, merit-wise, it's not a very good case.
The petitioner was arrested on September 30, 2023. Stop charge sheet was filed within the statutory period of 180 days, but without the chemical report. Stop. In fact, as learned State Council very fairly says,
No, it's on report. It's in a report.
Oh,
So your lordship will take this on board.
as learned State Council
একটা copy দেন না?
fairly points out with reference to the status report filed in court today, the
Sorry, Malad, only one.
chemical report is still not before the learned trial court. Paragraph, learned advocate for the petitioner, relying on the decision in Idulmiya, such and such, ACC online, says that the petitioner is entitled to default bail since a charge sheet filed sans the chemical report is no charge sheet at all. Stop.
Interim bail,
Paragraph,
end of February.
we have to agree with learned advocate for the petitioner. Stop. The charge sheet is still not before the learned trial court.
Interim bail, end of
Stop.
February. End of
We
February, matter
treat
to appear
this
24
application as one for statutory bail, and we are inclined to grant interim bail to the petitioner. Stop. This we do keeping in mind the fact that the issue as to whether or not the chemical report is mandatorily required to be filed with the charge sheet in an NDPS case, is pending consideration before the Honorable Supreme Court, and the Honorable Court, in all connected cases carried before it, has been pleased to grant interim bail. Next, accordingly, interim bail দিয়ে দিও যা যা condition. Next, This order of interim bail shall continue till the end of February, 2026, 26 or 25, or until further order, whichever is earlier. Stop. List this matter next. List this matter. Let it be on the same date, February 20, or you want some other date?
No, Lordship keeps it on the same.
February 26, when Learned State Council shall apprise us about the latest status of the matters pending before the Honorable Supreme Court. What have you written?
The police station case has should be 39/2023.
একদম গোড়ায় দিয়ে দাও একদম গোড়ায় দিয়ে দাও leave is granted to learned advocate for the petitioner to correct the police case number mentioned in the cause title of the bail petition. Date, not number. Date of the police case. Date of the police case.
Number is
Date of the police case. Police case number 9.
I'm grateful.
Lord, item number 60, I am for the petitioner, my lord. This is my renewal application, my lord. Lastly rejected on 1st May 2024. My lord, while rejecting, my lord, coordinate bench of this honorable court, my lord, directed the learned trial court to issue the framing of charge may be considered within 2 months. My lord, that order was communicated on 17th May 2024, my lord. That order, my lord, I have annexed, my lord, page 13. I am in custody, my lord, 2 years, 5 months, my lord. On the ground delay, my lord, I am paying bill.
My lord, after that communication, my lord, charge has not been framed because, my lord, there are several accused persons are still absconding, my lord. This is the problem. My lord, in this case, lordship is, if please wishes, I would like to file a report, my lord, because, my lord, 10 out of 10, my lord, on several dates, my lord, the table is with me in the as a memo of evidence. My lord, the accused persons are not appearing. My lord, that's why, my lord, charge has not been framed.
Granted bail.
Yes, my lord, some are granted bail, they are not appearing, and some are still at large.
Is it correct?
No, my lord.
It's not
Even the
correct.
principal accused persons have been granted bail, my lord. On the ground delay in.
Granted bail.
Yes.
They are not.
He's not appearing, my lord.
My lord, no.
Yeah, my lord,
My
then
lord,
I
I
will file
have
a
annexed the certified copy of order sheet, my lord.
Devojyoti, the petitioner is in custody for 2 years, 3 months.
5 months, my lord.
5 months. So he says that even charge has not been framed. Stuff he refers to an order dated May 1, 2024, whereby a coordinate bench rejected his prayer for bail. Stuff, however, the bench directed the trial court to consider the issue of framing of charge positively within 2 months from the next date fixed. And upon charge being framed, to conclude trial as expeditiously as possible without granting unnecessary adjournment to either of the parties. Stop. Learned advocate says that in spite of communication of the said order to the learned trial court on May 17, 2024, the same has had no effect. Paragraph. The state shall file a report on the next date explaining why there has been no progress in the trial. Stop. The report shall indicate, inter alia, how many witnesses the state proposes to examine. 15th or 20th?
20th, my lord, 20th.
20th. 20th.
Oblige, my lord.
That's very relaxation. That's very relaxation. All right.
Lordship, I'm praying for not today on behalf
Yes.
of Honorable.
Okay.
63.
My lord, in item number 63, my lord, I am praying for not today, my lord.
Every matter is not.
Today is not your day.
Yes.
Madam, for the petitioners.
For this case.
I'm praying for bail on the ground of detention, lengthy detention. I'm in custody for more than 15 months. Though the charge sheet has been filed on 1st, পাওয়া গেছে এর থেকে। কোত্থেকে কিভাবে?
So 15 months.
More than 15 months.
That means
Charge sheet has been,
that means 1 year, 3 months.
yes, my lord, 1 year, 3 months. 4th of January 2024, charge sheet was submitted. Previous year, 4th of January. My lord, April 2024, charges framed. My lord, till date, out of 10 witnesses, 1 witness has been examined in part. The last date was on 24th of December 2024. None of the witnesses turned. One of the next dates have been fixed on 4/2/2025 and 5/2/2025.
I shall call, I shall ask for a report.
The petitioner complains of inordinate delay in progress of trial. Stop. He says that he is in custody for about 1 year, 3 months. Stop. Charge sheet was submitted in January 2024. Stop. Charge was framed in April 2024. Stop. Thereafter, comma, only 1 prosecution witness has been examined, comma, that too, comma, in part. Stop. December 21, comma, 2024 was fixed as the last
December
date.
24th.
December 24, comma, 2024 was fixed as the last date of hearing. What happened? Nothing.
No witness turned up.
Stop. No witness turned up on that date. Stop. The next date fixed is February 4 and 5, comma, 2025. Stop. On the renewal, no. On the ground of long detention in custody, comma, the petitioner prays for bail. Paragraph. The state shall file a status report as regards the trial, indicating the reason for inadequate progress in the trial. Stop. The report shall also indicate how many witnesses the prosecution intends to examine. 15th.
15th. Retain its position.
Get.
List একই জায়গাতে। Great.
For the petition.
C5, my lord, can it be taken up the next day? Can it be taken up the next day, my lord?
My lord, this
Friday.
is the second time it is.
I understand, my lord, but
Your brother is in difficulty. Someday you will be in difficulty, maybe. Right, not today.
my lord, highly obeyed.
Madam, for the petition. Well, in this matter, from my direct position, nothing has been recovered. Allegation is that from the house of the petitioner, pencil has been recovered. But so far the charge sheet is concerned,
From your house.
yes, that is the allegation.
No, not from you, but from your house.
But in charge sheet, there is no details whether the house belongs to me or not. Man, kindly sees the charge sheet once more.
That will be decided at
Disown your house, say it's not my house.
My lord, from his house, 1188 bottles of fentanyl. He was absconding for 9 months. He surrendered only in the month of June. Charges have already been framed. 2nd, 4th and 5th of February for recording of evidence.
How many witnesses?
My lord, there are total 12 charge sheeted witnesses.
So he is in custody for about 6 months.
About 6 months.
absconded. You may again abscond.
Well, that
Grant bail.
When I came to know, I surrendered, my lord. I am not even arrested, my lord.
You're not,
Raid is being held
surrendered.
in his house.
You're not in
My lord,
your house.
my
And that's
contention
the
is
point of
that
time.
that house does not belongs to me. That is my instruction. Even in charge sheet, there is no details whether the house belongs to me or not.
Have you
No
mentioned,
bill,
have you
no
mentioned in
nothing.
your affidavit that the house does not belong?
No,
to
my
you?
lord, that I have not
So
stated.
you
in my
have not
petition.
mentioned in your affidavit also, the house does not belong to me.
In the petition, you have not said that.
That I have not.
So,
Yes, good.
Asun, learned council has.
My lord, may I pray only one thing, whether any verification that
Why?
with
No.
in charge sheet there is no details.
So you did not mention that this house does not belong to me. If you do not plead this case in your affidavit, how can it be?
My lord, additionally, there are statements of the locals that in his house the raid was being. Then, my lord,
Petitioner claims that the petitioner claims that he has been falsely implicated in this case since the house does not belong to him. Far from the alleged contraband articles were recovered. However, he is in custody for more than 6 months. As the investigation is complete, he may be enlarged on bail on any condition. Stop. Para. The learned counsel for the state opposes the prayer for bail on the ground that the petitioner absconded for more than 9 months and the contraband articles were recovered from the house of the present petitioner. Stop. The local witnesses have disclosed that the house belonged to this petitioner. Stop. Out of 12 witnesses.
No, charges have been framed.
Charges have already been framed. Yes. And further, there is only 12 witnesses.
Yes.
12 charge sheet named witnesses. The prosecution will conclude the trial within a very short span of time. Stop. Para. We have considered the materials on record. It appears that there are sufficient incriminating materials against the present petitioner. Stop. The petitioner did not swear any affidavit stating that the house where from the contraband articles were recovered does not belong to him. Stop. Considering the materials on record and CD, we are not inclined to allow the prayer for bail of the petitioner at this stage. Accordingly, grateful.
Obliged.
67, I am for the petitioner.
67, my lord, before my learned friend starts, my lord, I would beseech my lord, the report may be called for. He's paid for bail on grounds of delay.
1 year, 9 months, I am in custody out of 12 witness, only PW1 examination going on. Even PW1 examination going on, even chief has not been completed.
The petitioner complains of inordinate delay in progress of trial. Stop. He says that he is in custody for about 1 year, 9 months. Stop. Even the examination in chief of PW1 is not complete. Stop. Renewal, no.
No, first time.
He prays for bail on the ground of delay. Stop. Paragraph. Let the state file a status report explaining the slow progress, explaining the delay in progress of trial. Stop. The report shall also indicate how many out of 12, how many charge sheeted?
Not 12.
How many of the 12 charge sheet named witnesses the prosecution proposes to examine? 15th or 20th?
No, my lord, Wednesday.
No, Wednesday. 15th.
15th.
Wednesday will be home. How to? We'll get it.
15th. Para kore likhbe.
I'm good. I'm good.
কি এগুলো ওগুলো তুমি দিয়েছো
Cancellation of bail matter 966.
I'm for the petitioner, my lord. I'm praying for a day's accommodation, not today. I'm led by Mr. Mukherjee in this
Let
matter.
it be then next week, my lord.
2023.
Automatically, I think, এই এটা আজকে না হলে আবার কবে হবে cancellation? Next Tuesday. এই লিখে দাও তো, accommodation is paid for on behalf of the applicant. Huh? Let the matter stand adjourned for the day.
অপোজিশন দিয়েছি তো ওদেরকে সার্ভ করেছিস তো কোর্টকে দিয়েছিস
লাস্ট ডেটে ওদের ছিল রিপ্লাই দেয়নি আমাদেরকে
অর্ডারটা করি
Item number 967, Mr. Oyon Bhattacharya happens to be the arguing counsel. I'm praying for a day's accommodation, my lord.
Accommodation is paid for same.
নেক্সট উইক
Next week.
My lord, Thursday.
Next Tuesday. এই Thursday তো হবে না তো?
না না না
না, next Tuesday তো?
Next Tuesday. Deeply.
Thursday তো এইসব তোমার something.
But I'm for the petitioner.
Nobody is there.
Mr. Mukherjee,
Mr. Milan Mukherjee,
my lord.
on his ground, adjournment was sought for in last matter or matter before that. At this time, he may not be available.
Otherwise, this will not be taken. We filed this in in February. Last February, we had filed.
He is for the de facto.
I'm for the de facto.
Cancellation. This is cancellation.
For the accused who got bail from the trial.
Without him, we can't hear. You speak with him next Tuesday, request him to be here. That is the best we can suggest. What else can we do? Yes?
I'm for the opposite party number 2, my lord.
Who is that?
968.
Accused.
My lord, accused, my lord.
Accused.
My lord, Mr. Mukherjee appeared in this matter, my lord. He engaged in court number 34, my lord.
Yes. What do you want?
My lord.
He's praying for breathing time, nothing else. He knows that what is the fate of the application.
Can Mr. Singh proceed or you want adjournment?
Only adjournment, my lord. Subject to lordship, my lord. Kindly, my lord.
My lord, let it be last chance, my lord. Because
Accommodation.
he's been adjourned on several grounds on his ground.
Accommodation is paid for on behalf of the accused person. Stop. Let the matter stand adjourned for now. Stop. The applicant makes a grievance that on several occasions the matter has been adjourned on the prayer of the accused person. Paragraph. As a last opportunity, let this matter stand adjourned for the day. As a last opportunity to the accused. Let this matter stand adjourned for the day.
The victim also আছে
So আছে তার মানে এটা আমি অপোজিট পার্টি নম্বর 2 এ ছিলাম না লন স্যার আমি গেটফুল
969 and 970.
I'm for the petitioner.
Who is for the state? And who is for the
Opposition party, my lord, other day, my lord, appeared, and my lord, he was supposed to file the opposition. Opposition has been filed, but my lord, he has to place that on record.
Oh, Mr. Onno, no, Mr. Onno Charji, Mr. Alam.
Yes, Alam. Dhakna.
What do we do, Mr. Ghosh? Pass it over. We'll make a second call. If you can bring him, bring him. Pass over.
civil matter is present.
इसमें 9 से 10 मैप है
क्या करेंगे?
For the state.
Opposite party number 234, man.
Well, I'm for the petitioner, my lord. I was
You're also praying for not today.
well, I was praying for a week's accommodation to file a supplementary affidavit, my lord. I couldn't prepare it.
Hey, learned advocate for the applicant seeks leave to file a supplementary affidavit. Stop. Such leave is granted. Stop. Let such affidavit be filed before the next date with advance copies to learned advocates for the other parties. Paragraph lists the matter once again. Next Tuesday.
My lord.
14.
আজকের ঘরে আবার রিলিজ করে দেবে, বলবে যে আমার ডিটারমিনেশন anticipated.
Yes.
972
Mr. Mukherjee in this matter, Miller, kindly take it next.
So then it should go there. Go on its own motion. Hey, dekho.
My lord.
What, my lord, my lord?
My lord.
In CRR 1086/2024, rule was issued on its own motion by a coordinate bench. Stop. In our opinion, propriety warrants that these two matters be placed before that bench. Paragraph, accordingly, these two matters stand released from our list. Which is this? The stamp paper? No, what is this? SSC.
No, key, এটা কি? কেন? Personal ground ছাড়া how can you release it?
Rule was
part heard.
Mr. Mukherjee, rule was issued by a different bench on its own motion. It's only proper that it should be placed before that bench. This is what Mr. Ondi pointed out.
No, that way he's correct. But the question is determination is with your lordship now.
No, that's all right.
That is what I'm trying to say. Nothing more, nothing less.
It will be assigned. Or
be assigned then, my lord. Your lordship sends it to the Chief Justice, and then just assigned.
Stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
Yes. Rudra, তুই এমনি করিস না।
The other bench is there, that is why as an officer of the
না হবে হতা है, but you can't say that, no?
It's my submission, my lord.
All right.
So you have come late, so
Yes, sir.
that is the only.
The irony is the other way around.
Everybody
But
wants.
every day I tell him anything. But if I tell him anything, he said, I learned it from you. I was 8 years in your chamber. What can I say then, my lord? Tell me. What this? Well, 5 feet, dangerous. Anand Keshri, Rudra Adipto Nandi.
I've become deaf.
Milord, I am for the opposite party. Milord,
I'm for the petitioner.
Who is for the petition? Cancellation of bail, prayer.
my lord,
Yes.
I am the opposite party. Milord, this is my
Happy.
affidavit in opposition.
Yes.
Your Lordship, I have received a copy of the affidavit in opposition. I am paying for time to file a reply to this
Right.
opposition.
You received today?
I received it today itself.
Affidavit in opposition filed by the opposite party numbers 2 and 3. Be kept with the records. Paragraph on the prayer made on behalf of the petitioner, time to file affidavit in reply is extended by
1 week.
a week from date. Stop. Let this matter be listed again next Tuesday date diye dao, or you want Tuesday following?
Next Tuesday. Next Tuesday.
Next Tuesday date dao. So advance copy of the reply should be made available to learned advocates for the opposite parties. 3:30 something is fixed.
আগের ম্যাটার
মঙ্গলবার।
আগের ম্যাটার
We do 3:30. ও দাঁড়িয়ে থাকে না। এই অভিজিৎ ইম্পর্টেন্ট, প্রত্যেকটা রেকর্ড করো তো, 75টা রেকর্ড করো। Nobody appears for the petitioner. Let the matter stand adjourned for the day. Same 90-76. পরের দিন না এলে ডিসমিস করে দেবো। এখন পরে সেম
I'm for the petitioner.
You are for the?
I'm for the petitioner, but I have this difficult job of not pressing this application.
I'm the happiest person.
You have no idea how delighted we are.
Only one small thing, Your Lordship, the bail conditions already there, that may be adhered to, that observation.
That's
may
there,
be-
that's there. I'm
Just
complying
that
with
will
that.
help. That
Hey,
will help.
978. Learned counsel representing the applicant says that he has instructions not to press this application. Stop. Dismiss করে দাও তারপরে, হ্যাঁ। Paragraph D, needless to say, comma, the accused person who is on bail.
May I?
Why?
But since my learned friend is asking for withdrawal of the application and not pressing, but can any order
It's
be passed?
suo motu.
That's order is there, Lord.
Needless to say, shall adhere to the conditions of bail.
Lordship.
You've lost weight.
Perforce, Your Lordship, under advice. It was
I
going out of hand.
I see.
Lordship.
কি নাম বলেছে? এখন কি অবস্থা?
গরুটা কি? সমস্যাটা কি বলতো? পাচ্ছি না মানে এটা কি? তবে আগে থেকে চেক করবে না? হবে না তো একটাও, যাচ্ছেও না। Yes.
I am for the opposite party.
Applicant is not here. Abhijit.
Direction, my lord, we have already communicated one of the accused persons who did not appear on the last order. Your lordship, kindly see the last order of your lordship.
In all the three matters.
The three matters may be taken up together, but last matter, Rohit Shah, my lord, subsequently has been granted, was once again was arrested.
Mr. Das, please keep this with you. Keep this with you. When the matter is taken up, then file it. কি দিচ্ছেন ফেরত দিয়ে দাও। তুমি খালি রেকর্ড করো অ্যাপ্লিকেন্ট যেটা করেছো। Adjourn for the day. ওদের প্রেজেন্সটা রেকর্ড করে নাও।
One matter, my lord, has become infractions. That is what I am saying.
Right? You are the state. You are the applicant.
Applicant.
Oh, I see. Sorry.
I am for the opposite party. 81.
Then which has become
980, Rohit Shah. 981.
why
My lord, after grant of bail, he absconded. Thereafter, he was arrested once again. Then he was once again granted bail, and now the report is investigating officer is he is now absconded.
again absconding?
So we will come back with another application. So that
980.
980 Rohit Shah.
980 and the other two, what will we do?
On other two, my lord, we have served notice to one of the person, and your lordship in the last occasion.
But in the matter of
Legally noted, then in absence of
Mr. Mujumdar, it's impossible to read this way. Either you come physically or please don't intervene.
your lordship specifically noted, and this today, if nobody appears on behalf of the accused person, it will be.
Hey, 979 to দাও তো আগে।
My lord, I am for the, my lord, 975, 9, my lord, the opposite party accused, my lord.
You are.
My lord, I am not the, my lord, principal accused. Your lordship will find the allegation against me, page 26 of the charge sheet. Running page 20.
Yes, so therefore, Mr. Das, OP is appearing today.
Yes.
Do you want to proceed with your application, 979? Huh?
I'm ready.
As you wish, you can proceed.
So your petition and proceed.
979 টা দাও তাহলে 981 টা শোনো 981 টা রেকর্ড করে নাও learned advocate for the state oblique applicant says that this application for cancellation of bail has become infructuous paragraph accordingly ওই যে CRM whatever হ্যাঁ আচ্ছা এবারে 979 টা দাও
Out and out political case where conspiracy plays a major role. What happens, my lord?
9 কেন 980 দিচ্ছ 979 দেখাচ্ছি ওখানে
980 same case. Two accused person.
979, please tell. What?
So, my lord,
979.
victim and the main
979.
are the resident of the same.
Take the microphone, sir.
They are belonging to different political.
Mohammed Jisan,
79,
son of Mohammed Samim.
My lord.
Yes.
Yes. So, my lord,
When bail was granted,
bail was granted by learned session.
now what are the conditions?
তুমি ওনাকে যেটা দেবে আমাকে তো সেটাই দেবে ওনাকে একটা ফাইল আমাকে একটা ফাইল দিলে আমরা কি করে বুঝবো ওনাকে তো 79 দিয়েছো টা দাও
Mohammed Jisan, no?
Yes.
79?
হ্যাঁ মোহাম্মদ জিশান
979.
yes in 979 you are appearing for the
My
OP?
lord.
Yes
Opposite
So,
party.
my lord, this is this is of the gist of the order of the learned session judges. Though it was opposed by the learned
Ranvi,
of this
Ranvi,
officer saying that it is the accused person implicated with the help of 120 of Indian.
Please take the microphone.
Oh, yes.
Everybody is talking, then
So, my lord, the gist of the order of the learned session judge, whereby the accused person has been granted bail, is this: the learned PP opposed and tried to attract the attention of the court to the fact that there is no direct evidence, but it is connected. This petitioner is implicated with the aid of section 120B with the main accused person. But my learned judge says that charge sheet has been submitted, so there is no need for further custody. So she has been released on bail. Now my case is this: I have assailed this order of the learned session. But it is the victim and the main perpetrator of the offense are the resident of the same area. It is a person belonging to one political party.
According to him, Zishan is the main perpetrator?
No.
According to you, no.
No. Main perpetrator is still in jail.
Still in jail.
Still in jail. They play some role. In the entire chain, they play some role. Now, my lord, one person belongs to one political party, another person belongs to another party. One person's having some clout over some people in the area. So he was asked to join that political party. He refused. So a conspiracy was hatched up. Thereby, my lord, that the main accused person, main perpetrator, just, my lord, recruited one person to collect the miscreants, hired miscreants, so that the offense can be committed in that area.
What offense? 302?
302. Offense can be committed in that area, but persons will not be in that area. Persons will be hired from other area. So, my lord, that person hired 4 persons from different area, and they assembled.
you're saying all those things. Bail was granted.
Yes.
Now why? What is the grounds for cancellation? That is the only thing.
That is the perversity of the order. This is the fact I will have to say. I will have to say, my lord, that is the perversity of the order. Why? The nature and gravity of the offense, your lordship kindly appreciate. So, my lord, that person,
was he one of those 4 persons? This petitioner? No.
No, that 4 persons that did not know the locality and the victim. So they supplied the information to those 4 persons regarding the whereabouts of the victim, and the victim was identified by providing a photograph. From the person's possession, the photograph of the victim has been recovered.
Zishan?
Yes. From the CCTV, it appears that at the time the 4 person entered into the area with 2 motorbikes, there was interaction with these people. And they showed the way where they would found the victim.
All evidence have been collected.
Collected.
All evidences have been collected.
Evidence has been collected. We are proceeding with the trial. But thing is that, well, kindly appreciate, thing is that such type of conspiracy, such type of organized crime, which is not that one person out of a rage fired 1 person and 1 person. It is not like that. It is an organized crime. And in an organized crime, my lords, should be something different. It is my humble submission before your lords.
Why custodial trial is necessary?
Custodial trial is necessary because that enmity is still going on. In the area, the enmity between these 2 persons are still going on. Now, victim side, some persons are there who are influential. The accused person side, some persons are there who are influential. So, my lord,
has in any manner this person, Zishan, misused his liberty?
My lord,
after being granted bail, has he committed any unlawful act, anything?
No. Right now, my lord, but my lord, that last person, Rohit Sahu.
Let's take one by one. One by one.
My lord, after release, he didn't do anything. It is true. But listen, my lord, every possibility is there. The matter may erupt.
When was he granted bail?
11 March 2024.
2024. So for almost 10 months now.
But election is coming. Huh? Election is coming. That is why.
That your speculation.
My lord, speculation means, my lord, they do the work for only for that.
And এটা শুনে না এটা রিজেক্ট হবে যে ওটা ফেলে হবে রোহিত
And regarding Rohit's, same thing.
No, Rohit, my lord, Rohit was granted bail. Thereafter, misused the liberty. He was arrested.
Rohit, so you said infractuals.
Rohit infractuals.
That we have disposed of.
Yes.
No, there are three applications.
Two played the same role.
Ankit.
Yes, Ankit and
So Ankit and Zishan are similarly circumstanced. Anything more? Esho.
But who is appearing for Ankit?
Ankit, nobody the reject করছি তো।
But
Ankit has also been served, na?
Ankit, yes,
Well, I am appearing for Ankit.
Very well, you did not make any submission. The date of grant of bail is the same.
yes. Yes, sir.
তাহলে আমি একটা বলছি অন্যটা একবারে সেম হবে অর্ডার, হ্যাঁ? আমি তোমার বলছি 979টা। Stop. The petitioner, sorry.
The case diary.
Huh?
This is the volume of the case diary.
Don't threaten us.
That is right.
10 witness already examined. Today is also examined 3 witness.
The opposite party is one of the accused persons. Stop. He was granted bail by the learned trial court on March 11, 2024. Stop. Paragraph. The state has applied for cancellation of the bail granted to the opposite party. Stop. Learned advocate representing the state says that although the opposite party is not the prime accused, he played a prominent role in the alleged crime of murder. Stop. He was one of the persons who identified the victim to the assailants who had been hired by the kingpin, who is still in jail, who is still in custody. Sir,
Only Malad supply the motorcycle, nothing else.
Please wait for some time, please.
what do you think we are doing? We are allowing the application or rejecting it? You still don't understand what we are doing.
He could not fail.
Submit, my lord, that file.
You know? Please, sir, you don't understand.
My lord.
Chain of thought
Sorry,
gets
my lord,
broken.
my lord.
কি বললাম? Hired. In custody. Stop. Photograph of the victim was recovered from this opposite party. Stop. In this kind of organized crime, everybody's role is of equal importance. Stop. Further, the opposite party is a political person who has clout in the concerned locality. Stop. If he is allowed to roam about, there is every possibility of breach of peace in the area. This is in nutshell what you are saying. Paragraph, we have not called upon learned advocate for the opposite party to make submission. Paragraph, we see that the learned trial court, being satisfied, has granted bail to the opposite party, has done, granted bail, just has taken it up. On March 11, 2024, on certain conditions. Stop. The opposite party has been enjoying the privilege of bail for the last 10 months. Stop. It is not the case of the state that he has breached any of the conditions of bail. Stop. It is also not the case of the state that after being released on bail, the opposite party has committed any unlawful act or any offense. Stop. Paragraph. We must keep in mind that bail is still the rule and jail is the exception. Stop. Unless it is absolutely clear that the accused person, comma, if released on bail, comma, shall tamper with evidence or threaten witnesses or will abscond, comma, normally bail is granted. Stop. After all, comma, personal liberty, the right to personal liberty is perhaps the most important fundamental right after the right to life. Stop. Such liberty is not to be lightly interfered with. Stop. Paragraph. Learned advocate for the state also submitted that what elections are approaching?
26 election.
26. It 25 shuru holo jabe.
Preparation has started. Preparation has commenced.
This is the what election? These state elections are approaching in the year 2026. Stop. The free presence of the petition of the opposite party in the concerned locality will be detrimental to the law and order of the area. We are unable to agree, paragraph the unable to agree to agree with such submission. Stop. This is only a speculation. Stop. In the event the opposite party is involved in any unlawful activity, it will be open for the learned trial court to cancel the bail of the opposite party, even without any reference to us.
The order of the learned session judge is devoid of any condition. May I pay for one condition?
Yes, yes.
But they will not enter into the Barakpur commissioner.
Yes, yes. Paragraph, however, considering the facts and circumstances of the case, comma, we direct the opposite party not to enter.
With the cancellation of bail, this can be.
Yes, condition can be imposed.
We can do it. Not to enter the jurisdiction of the Barakpur Police Commissionerate without the leave of the learned trial court.
And to in case of appearance of the court, only on the date to appear when they will appear.
That condition also not there in the trial court's order. Unconditional bail.
See, can you see? Nothing is there.
Further, comma, the opposite party shall attend the learned trial court on each and every date of hearing of the trial.
Not to enter the Barakpur police station, we're going to accepting for the purpose.
Accepting for the purpose of attending the trial. Same order in the next one.
My lord, may I humbly submit one thing, my lord?
Yes.
If my lord permit. My lord, kindly make it not within the Barakpur Commissioner, but within the local jurisdiction of Jagaddal PS, my lord. Because I don't have any other residence. The Ankit Singh.
You can't have everything, Mr. Mujumdar. Then we will cancel the bail.
Pardon.
Hey, 979 and 980.
Record is being found. 978. Record পাওয়া যাচ্ছিল।
Have you followed, sir? Have you followed? Your bail was not cancelled.
Are you happy or unhappy?
I am happy, but the allegation, my lord, against me, page 20.
Very bad, very bad.
Supplying motorcycle.
Only supplying motorcycle.
That is, my lord,
For killing. Daku speaks bolle to.
Oblige, my lord.
Granted your client interim bill to attend the daughter's
And
marriage.
then we surrendered as
Oh,
per your
sir.
lordship direction. Now on merits we are coming before your lordship.
Subject to before
My lord,
my
I am in. Acha, bolna.
My lord, subject to whatever falls from your lordships. My lord, there are series of 4 matters as normally happens. My lord, will it be my lord's pleasure to hear the petitioner's and then in one go I'll reply, or should I reply on one to individual?
Individually, there's no point.
They are all more or less the
Same footing.
Factual matrix more or less is the same, but the basis of bail application as to how many days they are in custody, what is their complicity, these are different as per our report.
Very well, you can deal with them separately, but we'll first hear all 4 of them.
My lord.
Then you
can.
My lord, then that is what, because I
junior ke রেখেছে না তুই বড়
আমি কোথাও যাব না, আমি এখন I will hear you sir.
না I am that's part.
আবার স্যার আবার চলে যাব বাইরে।
My lord, incident is the 22nd of March.
The gown is looking nice.
Indebted for my lord's compliment.
Yes.
My lord, this is from your hometown.
Yes, you did tell us.
My lord.
I also wanted one, but I couldn't afford.
My brother gave it to me.
Of course, everybody gives you only.
No, my lord, he gave me one from Malad, that shop, your lordship in 91
Right,
plus.
Ryder and Ames, no.
No, your lordship, Ethan
Eden
Ravenscroft.
Ravenscroft.
That was the first
Eden Ravenscroft.
shop your lordship told me in 1991.
Right.
That lady Malad, who was he's now the public prosecutor there.
Right.
Chitra something, Malad, Gosai. Then, Malad, I have that also, Mark, Ethan. This is from Stephen, Stanley in front of the Malad.
Well, Stanley Lee is also good. Stanley Lee is also good because recently Stanley Lee is the only.
Mr. Trivedi, I am more familiar with Kach Kumar.
So am I. So am I. So am I till 2019 when I went there for and I went there and I made it a point to visit all these lanes where the entire legacy of the robes which we wear comes from. So that is how I got the information. I had no idea about this in 1991, what your lordship and my learned seniors discussed.
Very well. Yes.
Yes. Now, Malad, this case was registered on the 22nd of March 22. Malad, I was arrested on the 25th of March 2022. An SIT was formed on 22nd, but thereafter, on the 25th of March, Malad, CBI took over. Right, but I don't want to trouble your lordship. So, Malad, I am in custody exactly 1,031 days minus 7 days. 7 days which your lordship had given us very kindly attended the marriage. 1,020 days minus 7 days. So 1,013 days. Right, Malad? Now, Malad, there are 151 witnesses.
116 you had said?
No, Malad, supplementary 3 charges.
I see.
Added subsequently, Malad.
26
161, 151 witnesses. Malad, out of them, 19 have been examined. Tell me what that? 19 have been examined. Now, Malad, the present role of the present petitioner is, according to them, when Badhu Sheikh was killed or murdered, he was taken to a hospital. Now, in that hospital, Malad, according to the prosecution, I was the person who instigated the followers of Badhu Sheikh to take revenge. So, the act attributed to me is twofold here. One, they say it's a conspiracy under 120B, and the other, they say, is under section 109, abatement. So, Malad, what happened? So, initially, when I was made an accused, they're going through the 161 statements and all, Malad. If my lord would see, nobody stated anything pertaining to the factor of me being present at the place where the subsequent incident took place of burning the houses and killing those persons there in the house. Now, Malad, this part has been brought by them, that is the CBI, in the third charge sheet, supplementary charge sheet, which they filed, and your lordship will get it at page 258.
What was your stature?
I was the Pradhan. I was the Pradhan.
Leader.
The 258. থেকে আরম্ভ হচ্ছে relevant পার্টটা আমি পড়ছি but 258 is the third supplementary. Malad, I stand corrected, Malad, I was the block president. Malad, the relevant part is at page 291.
Gracias. 291.
Yes, Malad. Malad, 16.11. The CFSL report has confirmed the use of explosive substance by the accused person in alleged crime arson, and request has been sent to the competent authority to give consent under Section 7 of the Explosive Substance Act for trial of the accused person under section 3 and 4 of the Explosive Substance Act, and on receipt, same will be filed before the Honorable Court concerned, which, subject to correction by the learned DSG, there are two DSGs here, Mr. Trivedi. So, my lord, subject to what he says, that consent has not been given under section 7, at least we are not aware of, even though charge was framed and the trial has started. Now, my lord, see the next paragraph, 16.12. During investigation, no larger conspiracy came to light as the incident of arson in which 10 persons were killed was started by the supporters of deceased Bahadur Sheikh to avenge the murder of Bahadur Sheikh on the same night after around half an hour of the death of Bahadur Sheikh. So, Malad, it was something which was done on the heat of the moment. And the consequence was there were never any prior meeting of minds or a prior concert of minds, which would have resulted in having a conspiracy to kill these persons. So it happened within half an hour of the death. So it was spontaneous. But subject to corrections, but this is what I've interpreted as page 291. Then, Malad, the most important part is 16.14. One of the last line of that page, 16.14.
No further investigation is pending.
So, my lord, if filing of the sanction or the consent a part of the further investigation or not. Now, if that is not given, my lord, then the question of the charged under 3 and 4 will not arise. Even though, my lord, charge has been framed under 3 and 4 without the consent. Now, that's the first limb of my argument. Now, my lord, please come to this first charge sheet in which I was charge sheeted, even though I was not named in the FIR, my lord, I was charge sheeted. And it starts at page 53, paragraph 16.3. Well, I'll just give your lordship a note, of which I don't know whether I've given it to your lordships or not. A note like this with the what points I would take. What is the statement against the present petitioner? My something like this. দাদা এটা একটু দাও মাইলটকে তাহলে আমি করে দিয়ে দেবো তাই
No.
মানে this form so that it cut shorts the time, my lord. I'm sorry, I have one, the other one is I've noted it down, so my lord, you pardon me. I'll give to Justice Sinoroy, my lord. I'll have it photostat and give it to lordship. Now, please comes to page 53. The first charge sheet. The role of the present petitioner.
Page number?
153. But inner page at the bottom 26. But inner page at the bottom 26.
Yes.
It is revealed that the initial investigation was conducted by the local police and SIT CID West Bengal. During investigation conducted by the IO of PS, 20 accused persons were arrested. Accused Anarul Hussain was arrested by so-and-so. 6 more accused were arrested by CBI after taking over the investigation from local police. During the course of investigation by CBI, 2 accused persons were declared as child in conflict with law and referred to Juvenile Justice Board, District Birbhum, Churi. Accused Lalon Sheikh and Jahangir Sheikh, both FIR named accused persons, are absconding, and non-bailable warrant against both the accused have been issued by the learned court on 22nd of June 2022. The proclamation has also been published against the absconding persons, so and so. Now, this is the relevant part. 16.4. Investigation revealed that Bahadur Sheikh, son of so-and-so, was Upapradhan of Barshal Gram Panchayat and was a close associate of accused Anarul Islam, Block President Rampurat. It is revealed that on 5th of January 2021, At about 20 hours, Babar Sheikh, brother of Badu Sheikh, resident of so-and-so, was murdered in this case. FIR number 4 of 21 of Rampur PS was registered against Lalon and others. Badu Sheikh was having suspicion that Shona Sheikh and his associate were also involved in the murder of his brother, Babur Sheikh. Otherwise, also, there was a previous rivalry dispute within Badu Sheikh and his followers on one hand, and Polash Khan, Shona Sheikh, and their group on the other hand, over the issue of collection of dak, unauthorized collection of money, as well as for acquiring documents over the village of Baktui and surrounding areas. Investigation further revealed that on 21st of March 22, at about 20:30 hours, Badu Sheikh was murdered at Baktui Mode by charging country-made bombs on him and using illicit firearms. In this case, FIR number 168 of 22 dated 22nd of March 22 was registered against Polash Khan, Shona Sheikh, Sonju Sheikh, son of so-and-so, and others. After murder of Badu Sheikh, the associates and supporters of Badu Sheikh suspected that the rival group of Shona Sheikh was responsible for the murder of Badu Sheikh. Therefore, being agreed by the murder of Badu Sheikh, associates and followers of slain Badu Sheikh, upon instigation by accused Anarul Hussain to avenge the murder of Badu Sheikh by killing the rivals, retaliated and attacked the house of their rival group situated at Boktui with deadly weapons. With the intention to kill the rival opponent present in the firehouse, accused associate and followers of slain Badu Sheikh hurled country-made bombs, poured kerosene on the hide of Mir Lal Sheikh. Mir Lal Sheikh is one of the witnesses who have already been examined. I will give the copy of them. So, in respect of Anarul, the note I have got, which I have prepared subject to corrections, it relates to 5 persons who have explained the role played by me. One is Bihilal Sheikh, second is Nekiel Sheikh, Neglal Sheikh, third is Kiam Sheikh, fourth is Sujan Sheikh, and the fifth is Jamadul Sheikh. So, according to them, these are the 5 witnesses pertaining to my presence at the hospital and the instigation allegedly given me there, where Badu Sheikh's body was lying, to the followers of Badu Sheikh. This is the role ascribed to me. Now, if your lordship then comes, I was saying, then, if your lordship comes to the next page, investigation revealed at page 55, 16.6. Here, there is no whisper about me. Then, will please comes to 16.9. Malat 16.8, sorry, 155. 16.8, the last paragraph. Since Badu Sheikh and his associate suspected that Babar Sheikh was murdered by Shona Sheikh and his associate, gradually enmity cropped up between the two groups because of the said suspicion and other issues of regular harassment of Shona Sheikh and his associates of Badu Sheikh. Therefore, after the murder of Badu Sheikh on so-and-so, family members and associates of Badu Sheikh suspected that Badu Sheikh was also murdered by Shona Sheikh and his associate. So, we have 2 different groups, Shona and Badu. So, Anarul is not a party there. He is not a party who wanted dominance, or I think, it's not there anyway. Now, next, I'll just not trouble a lot, 9, at page 56. Investigation revealed that on 21st of March 22, at around 20:30 hours, when Badu Sheikh was murdered at Boktui Mode on NH so-and-so by charging Bonamem, supporters of Badu Sheikh, namely Lalan and all, now, apart, comes 4 lines from the bottom, apart from the above persons, just I don't want to trouble a lot. See, my name transpires thereafter. Other followers and relatives of Badu Sheikh also started assembling at Rampurat JMCH. It is revealed that about 9 p.m., Anarul Hussain, the TMC block's president of Rampurat, also came to the hospital and went to see Badu Sheikh. After some time, he came out of hospital and was surrounded by the supporters of Badu Sheikh who were in anger. So, my presence is at the hospital, not at the PO. it is revealed that the murderer Bhadu Sheikh, when accused Amarul Hussain reached at Rampurhat Government College, he, being close associate of slain Bhadu Sheikh, entered into a criminal conspiracy with the angry supporters of Bhadu Sheikh, namely Azad Chaudhry and so, and others, for taking revenge against Sona Sheikh and others in retaliation of the murder of Bhadu Sheikh, as they all suspected that Sona Sheikh and his associate had killed Bhadu Sheikh. It is further revealed that in pursuance of the said criminal conspiracy, Anarul Hussain instigated the supporters of Bhadu Sheikh to take revenge of the murder of so-and-so by burning the houses of so-and-so and his relative. Now, this with page 291, where they have spoken of no conspiracy, it was on the spur of the moment, and it was no premeditation because of the death. In retaliation, this happened. Accordingly, next 1611. কার আছে চারটের সময়? হ্যাঁ, তোর তাহলে আমি চালাবো। তোর আছে চারটের সময়? আচ্ছা, বসতে another 5 minutes is that. Accordingly, in pursuance of the conspiracy and upon being instigated by the accused Anarul Hussain and a few other accused persons to avenge the murder of Bhadu Sheikh, the aforesaid family members, associates, supporters of Bhadu Sheikh, accompanied by other persons whose name emerged during the investigation with a common intention, attacked the houses of Sona Sheikh and his relative, residing in village Baktui, hurled country-made bombs, set the houses of rivals on fire by pouring kerosene oil and petrol with the intention to kill their relatives. They ultimately killed 10 whose only fault was that they were family members of Sona Sheikh, a rival of Bhadu Sheikh. My lord, your lordship will never find, apart from what they were said about being instigated. Now, the instigation, if we accept it even also, the instigation happened at the hospital. If we accept it for argument's sake, but I'll show you subsequently what they have said. The instigation part would mean something like kill.
So, President, you are the president.
So, Malad, what happened? Malad, what happened there?
Somebody sought help from you, informed the police.
Correct. I was coming, Malad. I was just coming to that, Malad. Well, I was coming to that. That he was asked by phone to call the police. I said, no, I will not call. This was another that I was interested in the murder of the other persons of Sona Sheikh. Now, Malad, interestingly, Malad comes to 16.30. Investigation revealed that in furtherance of the criminal conspiracy and with the common object to revenge the death of Bhadu Sheikh, accused Shamir Sheikh, father-in-law of Lalon Sheikh, also instigated the above-mentioned accused person in unlawful assembly by asking them to burn all the houses of the rivals of Bhadu Sheikh. He also asked the member of the unlawful assembly to bring petrol and burn their houses. Accused Shamir Sheikh also ordered accused person in the unlawful assembly to throw bombs on the houses of Sona Sheikh and his relatives. So, my lord, the role of this gentleman goes away and the Shamir Sheikh comes into play, that he was the person. And there are two persons who, with petrol cans, went to the petrol pump from where they brought it and they burnt it. There is no whisper of Anarul being there at the spot. But what I would like to do is reading the whole thing will not serve a purpose. I've made a note of it. I will give that note to my learned friend. And then your lordship will hear me on that. Only to that note. Gives me, I'll give the note tomorrow itself. So you fix up a date so that we can do it. Subject to Mr. Dhiraj and Mr. Mozumdar's date and time. নোটটা দাও আমার ওই নোটটা দাও একটু I'll give it to him by tomorrow. I'll place it before your lordship tomorrow itself. এটা আমি নিয়ে নাও বাড়িতে একটু ক্লারিফাই করতে তুই কার জন্য আছিস তখন যাও বাড়ি নোট করে দিয়ে Well, day after tomorrow, that is matter is there.
Monday.
This one, no. Day after tomorrow is that matter. NIA.
This one, Monday.
Same time.
3:30.
And no, don't keep anything at 4, please.
No. আর কিছু রেখো না।
I'll finish it on that date.
আর কিছু রেখো না সেদিন, হ্যাঁ?
এই তুই আছিস তো Monday?
এটা কি আলাদা করে হচ্ছিল?
আচ্ছা, থ্যাংক ইউ বলা হয়নি তোকে। জেপি মল্লিকের জন্য।
কোথায় ভাই উইথ করে তো দেখতে পাচ্ছি না।
আর বেশি অলওয়েজ মাইক।
তুই একটা হিরো। ভগবান গায়ে রং দিয়েছে, লুকস
Heard
দিয়েছে,
Mr. Milan Mukherjee, Kamalan
দিয়েছে,
senior
what?
advocate appearing for the petitioner
কোপটা দিয়েছে লেটে।
in CRM DB 1468 of 2024. Stop. He does not conclude. Stop. List the matter once again on Shamne Sombar, marked 3:30 p.m.
Grateful, my lord.
আচ্ছা এটা দিয়ে কাট করতে পারছি। হ্যাঁ আমরা তো ভুলি আমি দেখিয়ে দিচ্ছি একদিন মানে সো বিজি
তো স্টেট কে আছে?
স্টেট কৌশিকদার ইয়ে আমাদের বুস্টার রয়েছে।
Who's on the other side?
মানে মিস্টার কুন্ডু এন্ড মিস্টার রয়, মিস্টার কুন্ডু এন্ড মিস্টার রয়, মিস্টার কৌশিক কুন্ডু and মিস্টার
Public prosecutor, Mr. Roy.
my lord not available repeated times, my lord. This is being adjourned only for
No, this was fixed. This is appearing in the list. Mr. Kundu appeared before. We have not seen Mr. Roy today.
yes, that's true.
Kundu.
I also haven't seen him, but Mr. Kundu was there.
Yes.
My lord, may I propose one thing? My lord, may I conclude my argument? Because my lord, I'll hand over my note to them. My lord, perhaps that would be better.
Yes, yes. You only release us at 5 minutes before 4:30.
Okay.
We have some administrative work. What was the question of law?
My lord, direct FSL has been sent to the learned court directly.
Right.
There was no supplementary charge sheet. But the dates have been mentioned in your lordship's order dated 2nd December 2024. That is what. Mr. Roy he left, my lord. He has not well.
Very well, you be here.
Yeah,
Let him
we have
conclude.
completed.
Huh?
We have my Mr. Roy on the last occasion completed his submission regarding that
Yes,
matter,
yes.
my lord.
He-
That he has said, well, he has relied on paragraph number 53 of Sanjay Dutt's judgment.
Oh,
He says that I will not submit anything more. My lord, if he wants to make any further submission, my lord, he can.
very well.
My lord. My lord, kindly take up section 2R of the CRPC at page number 2 of this compilation. My lord, I have made it a part. Page number 2 of the compilation. Page 2, section 2R. Police report means a report forwarded by a police officer to a magistrate under subsection 2 of section 173. This is the definition of police report. Now, before going to section 173, my lord, kindly see page number 6 of this compilation, that is 190. How cognizance can be taken. Page number 6, my lord, 191 subsection B. Subject to the provisions of this chapter, any magistrate of the first class may take cognizance of any offense, B, upon a police report of such facts. So unless and until a police report is being filed, magistrate cannot take cognizance.
Say that. These are not cumulative, doesn't say and upon. They're separate, disjoint.
My lord, A and C are connected to other things, because A is upon receiving a complaint of facts which constitute such offense.
Private complaint.
Private complaint. And my lord, C upon information received from any person other than a police officer, it's like suo moto.
Yes.
So A and C are, my lord, subject to your lordship's confirmation, my lord, this is not related to our situation.
No, they are not, correct.
Only B.
Yes.
Only B is important. That upon a police report of such fact. Now, my lord, kindly come to section 173 2I. What is police report?
in practicality.
Where is that?
Page number 9. 173 2I. My lord, as soon as it is completed, my lord, these are the words it should be emphasized. As soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offense on a police report or report in the form prescribed by the state government. So, my lord, there are 3 prerequisites to call up a paper as a police report. First one is that, my lord, the investigation has to be completed. This is one. Second one is that this has to be forwarded by the officer in charge. And it should be done in the prescribed form. My lord, 93 of PRB, it should be. But my submission gets strength from subsection 8 of 173 once again. That is further investigation. Nothing in this section shall be deemed to preclude further investigation in respect of an offense after a report under subsection 2 has been forwarded to the magistrate, and where upon such investigation the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed.
Mr. Mahapatra, in the context of the present case, what are you trying to establish?
Well, what I am trying to establish is that, well, this FSL report traveled directly to the court.
Yes.
This was not appended in the forms prescribed. In the form of supplementary affidavit.
It would not become part of the charge sheet.
Exactly. Precisely that is the thing. Precisely that is the thing.
What prejudice is caused to you for such irregularity?
Whether
it is curable irregularity or
absolutely incurable. Because what I am saying so, because my lord, your lordship would also take up section 36A4 of the NDPS Act. 36A4 says, your lordship knows much better than me. 36A4 says that if an investigation is completed within 180 days, there is no problem. Beyond 180 days, if the investigation officer wants to investigate this matter, public prosecutor will move an application. Whether that has been done in my case? No. This is being happened in each and every case. Whenever I'm going a little bit beyond of my case. Whenever your lordship is granting bail in connection with Idul Miya, your lordship would see that whether any 36A4 has been moved or not. If a 36A4 the application has not been moved, the investigation officer cannot investigate. It's a special statute. 36A4 has an overriding effect. My sum and substance is that if the charge sheet has been submitted with the FSL report and the 36A4 has not been moved, the person should be discharged. I'll go to that extent. Person should be discharged, not bail, my lord. Discharged. There is no offense. No application has been moved. Who prevented them to move this application?
Take up this issue for discharging at the time of consideration of charge.
No, because charges cannot be framed. I have to be discharged at the time of filing charge sheet, this purported charge sheet, because this has not been done. This is exactly the thing why, my lord, this Rakesh Shah judgment has been passed. Your lordship would see Rakesh Shah once.
But that issue is pending before the Honorable Apex Court.
Yes.
And what prejudice has caused to him if it is directly traveled to the learned judge?
Absolutely prejudice, because this will curtail my Article 21.
The investigating agency here is basically postman.
No,
He is just collecting the report and submitting before the learned trial court.
My lord, your lordship would kindly come to. Your lordship would kindly come to page number 16 of my compilation. This is a celebrated judgment. Khaja Nazir Ahmed. Page number 16, page number 25.
Do it in that manner or don't do it.
This says that a magistrate cannot collect evidence on behalf of investigation. These are the separate squares. One will not overlap another.
Evidence. It was sent to.
What he is submitting is actually that magistrate is collecting evidence in that case, because it traveled directly to the magistrate.
No, that
It traveled directly to the magistrate. What prevented them to collect this? Every document which is being collected during investigation, that has to be authorized by the investigation officer, and
even the chance.
This has to be done by the investigation officer. The investigation officer will sponsor each and every document. Each and every document.
Where is the curable irregularity or incurable?
Incurable defect, subject to your lordship's confirmation. Incurable defect. Because my understanding is that if 36A4 has been incorporated, this becomes OTOC, CRPC, regarding 167(2). Regarding 173, this is a specific provision. PP will move an application for extension of this investigation. There is no problem. Another 180 days he will get. Another 180 days. Subhash Jadhav deals with this. Rakesh Shah deals with this. But I have made everything a part of this compilation. Another thing, Mr. Roy, on the last occasion, has submitted that there cannot be an oral prayer. That can be. That is coming from Rakesh Kumar Pal. That is at page number 27. It will start. Paragraph 40 and 41. That it can be done orally. Your lordship knows this. In fact, I've been blessed with so many orders on this aspect. This has been followed in M. Ravindran. Mr. Roy has harped on paragraph 53 of Sanjay Dutt. Paragraph 18 of M. Ravindran at page number 106 specifically deals with this. That oral prayer can be made, and it is the incumbent duty of the magistrate or the presiding officer to appraise me that see, this is the situation. You may get statutory bail. Are you inclined to furnish a bond or not? So oral prayer can be made. Subhash Jadhav, paragraph 31 is the penultimate paragraph. It says 31.1 at page number 133 of my compilation. Right of an accused to statutory bail upon expiry of the period of detention prescribed under section 36A subsection 4 of NDPS Act is an inchoate one till he avails of his right by seeking statutory bail either by way of an application or even orally. Hence, he cannot be released automatically on statutory bail on the mere expiry of 180 days, even if the prosecutor has failed to submit seeking extension of detention in terms of provision to section 36A subsection 4 of Act before expiry of the said period. Page 133. I'm reading. Your lordship wants NDPS Act. Paragraph 5, 31.5 at the same page. Prayer for extension of period of detention must be on the basis of a report of public prosecutor which must record progress of investigation and spell out specific reasons to justify further detention beyond 180 days pending investigation. Read this along with point 6, 31.6. Special court on the basis of report of PP and materials in support of such plea must be satisfied of the twin requirements. A, there is an appreciable progress in the investigation. B, there are specific compelling reasons to justify further detention pending investigation. Each case has to be decided on its own merit. For example, this is why we are getting bail by citing Idul Miya. For example, failure to complete investigation solely on the score of non-submission of FSL report on the samples drawn from the contraband is an institutional shortcomings. This by itself may not justify further detention pending completion of investigation. We are getting bail for this particular line. Last last question raised by Mr. Roy, that then what is this? Then what is this scene? Why? How should we interpret this scene by magistrate, seen by a special court? Is it not on cognizance? My answer is no, because my lord, I have made it a part, page number 130, 140. My lord, this is from PRB, subordinate court rules, Calcutta High Court subordinate court rules. Rule 72B. This is a police file. In colloquial terms, my lord, we say that that at 2 p.m. we have police files. Police files means this thing, this document. Police files means all the documents prepared and maintained by the police in connection with the prevention or investigation of an offense against an accused or accused under the provisions of the code or any other law and presented before a magistrate for orders. These order sheets, all these documents like FIR, Caesar list, or any document, these are actually police files. This is not cognizance. Next page, prepared and maintained by the police. How we'll interpret this? When the police establishment prepares or maintains the file for presentation before the magistrate in connection with a criminal case, it is to be known as police file. Other authorities also prepare and maintain similar papers or file. For example, excise authorities, such file is not known as police file. Rather, locally they are called as excise files and so on. This is merely a police file. This document which has been traveled from the FSL lab to the magistrate, this scene means it has been taken on record in the police file. That's it. Nothing more, nothing less. Nothing more, nothing less. Your Lordship has already seen that when cognizance can take place, when police report comes. Police report means it has to be done in specific format upon completion of the investigation officer and in the prescribed form. That's it, my lord. I rest my case.
Anything further from your side? No.
Nothing. Mr. Roy has already concluded, but only one thing my learned friend is harping on. Please,
What Mr. Roy argued, we can't remember.
Well, he has shown paragraph 53 of Sanjay Dutt.
That is all.
That's all.
That's all.
And
Beginning.
my lord, what he is trying to establish that oral prayer regarding 36A, and we are on the limited point here that whether judgment of Idul Mia will straightway apply to in this case or not.
Your Lordship would get this from my compilation also. Paragraph page 106. This is where this Sanjay Dutt has been distinguished, has been interpreted.
This does not address this issue.
No, not at all.
This
Not
is
at
about,
all.
you see, right has to be exercised before the charge sheet is filed. Once charge sheet is filed, the right goes.
Yes, Miller. Now his point is, but what is his point?
Simple point. The FSL report has directly traffic.
Yes, directly traffic.
Only.
There is.
That's
It does not along with the police.
Along with the
yes,
along with the charge sheet.
Yes, that is the only point. That
Yes,
has
Miller.
not been redressed here.
But in that case, he has to establish how he is being prejudiced.
Whether
if it is
paragraph 53 of your decision is sufficient.
No. That is
It is not on that point at all.
What Mr. Roy has said. How can I?
No, so tell us. We'll then give you some more 10 minutes time someday to address, because you have not addressed this point. You've given a copy of this.
I have already handed over.
Yes,
I've already handed over.
He is saying the statute prescribes a particular mode. What a police report is, he's giving the definition. All these materials he has filed.
Consider and come back.
If you wish to address us, issue, একটা তারিখ দিন
Mr. Roy has submitted.
4টের সময় Let him come.
But for,
Then at 1 o'clock. Someday at 1 o'clock. Better because Mr. Roy may not be available at
Yes,
4.
yes, Millard. Now he is very sick, Millard.
একটার সময় দাও একদিন দেখো Mr. Mahapaତ୍ର, our learned advocate for the petitioner, concludes his submission. Paragraph lists the matter once again on এই উইকে একটার সময় কোনোদিন নেই. When do you want it? Tell us, give us a date.
Any day, Mr. Roy is coming every day, but he leaves early.
Sir,
But
you are
any
not
date,
helping us, Mr.
subject to your lordship's convenience, any date, Millard. I will inform him.
Sorry. হ্যাঁ কি
Because
পরশু হবে একটা পরশু to day after tomorrow. Before we forget everything, finish it off.
day after tomorrow,
Marked 1 p.m.
day after tomorrow at 1 p.m.
No, দাঁড়াও. No, Friday? হবে? Monday? Monday,
At 1
marked 1 p.m.
Deep request.
এই এটা রাখো তো ওই নোটটা এটার সঙ্গে এটা হারিও না.
হ্যাঁ অ্যাকচুয়ালি একটা রং সাবমিশন হয়েছে স্টেটের তরফ থেকে